All right, everyone. Lyric Armstrong, your real estate agent and advocate, and certified paralegal commentator for this YouTube channel for the RE Advocate. Someone asked me, why are you interested in the YSL case? And I wasn't like forever in 3 days. Like it's been going on for 3 million years. And I just finally like caught the bug. It's drug me in. And even though I advocate for homeownership and I do advocate in real estate for legal matters, I'm also a certified paralegal that's worked in different fields of law, usually labor and employment, family law, real estate law. But hey, ain't nothing like a good court, right? So this entertainment is sucked me all the way in. I do mostly civil, and this is a criminal litigation, but it is very interesting to watch because there's so many newsworthy things going on. Which brings me to the point. I do wonder still how, oh, my jacket behind me. I still wonder how the jurors are on this case for 100 days, that they've remembered what happened day one. Just do you remember? Do you even remember the first witness? What were they talking about? And then two, that they've been able to keep themselves away from the news coverage of this case because there's so much newsworthy litigation going on to where it's like, you sure you didn't see a TikTok or nothing? They are vested, okay? God bless their souls. They are in it for the cause. Big ups to the jury. Big ups to the jury. Big ups to the jury. I can't say that enough because I would be like, Your Honor, I saw like you had recused and then it did a thing and something else happened. I don't know. I saw a meme that said Little Woody was a liar. I don't know. I would be coming up with stuff because you got to get me off this case. But no, I'm just playing. Obviously, it is our civic duty to be on the jury. And so I do thank them for that because it is a major sacrifice. We talked about it before. I think they're $25 a day. They're 100 days in. Clearly, they've had extensive breaks. I think there were some health issues, some other scheduling things. It took almost a year to put a jury together. It's a lot. This case is going through a lot. But it really brings me back to the core question that I had for the prosecution the other day. Do you have a case? Do you have one? Like, you might want to reevaluate that because Georgia looking funny in these streets. You're looking real weird. And it's not good. This is election year. You got, what's her name? Bonnie Willis looking foolish because y'all out here prosecuting something you can't prove. It's one thing that something could be true. This is, oh, I love this. I say this a lot to our clients when I have to meet with them and even some friends of mine when we're talking, you may believe something and you may know it's true, but can you prove it? That is what court's about. Can you prove it in a court of law with the rules, with the rights? I think we talked about how Judge Glanville is like, I'm just trying to, make sense of this case. It's like, no, 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 just call the balls and stripes. You're not supposed to like package up the case for the prosecution to make it make sense because you can't trample over the defendant's rights. Because he was like, you're dragging the case along. And it's like the defendant's like, I'm objecting because you guys are doing tomfoolery. Like you're foolishly working right now. You are being um, improper with your rulings and you're being improper with your conduct. And this is, I have to object on hearsay. I have to object on relevance. I have to object. So it's like, I have to preserve the record. This is my job up here. And it's prolonged because I don't think the prosecution has a provable case. So I think I can be a little nicer now, even though I'm still wondering why we have rap lyrics in the case. But I'm just going to say, is it provable? Whatever your case is, prosecution, is it provable? And if it's not provable, cut it off. I think it's like you're so much in the weeds and you're so knee deep, you just can't. And you're just like, I can't stop, won't stop, got to keep going. It's like, and you just, but if you ever heard the phrase, don't throw good money after bad, it really goes into if the investment has gone down, don't throwing money in there because it's going down. It's down. Unless you're, investing against the marketplace, if you're doing something else. But just in general, like you don't throw good money after bad. And the prosecution, I feel this is my feeling because I'm trying to figure out why the heck they are putting up liars on the stand that they know there's liars and they're doing all of this nefarious or just they're so like it has to happen We have to get this conviction. Um, and they were naming Mr. Williams second in the indictment list, but he's like they go for him like he's the kingpin, right? So it's like, who is it? Um, so I don't know. I don't know the details of that, but I guess for them, if they don't prove this first six, then all those others become very hard to come after because they got to prove the basics. They got to get the foundation provable. So maybe that's why they can't stop. They can't turn around. It has to be done. But if it takes 100+ days to do it, I don't know. I would say you don't have a case because if I'm the juror, and I'm gonna just be honest with you, this is personal. This is personally me, just I'm gonna be honest. If I'm the juror and I'm sitting through 100 days of this case and my life has changed because y'all got motions and ex partes, that's why I had an issue with my so ex partes, you have motions and all this going on that keeps cutting the timeline and has prolonged my activity to be a part of this case. And you have 100 days of trial, but yet it's been over 18 months and I haven't tried to get off the jury. I haven't tried to be sick. I haven't tried to be like, I saw a thing and that thing, I was on YouTube and I was just watching Emily D. Baker. She just broke it down. Like, I love me some Emily D. Baker. She the boss. I went on there. Like, if I didn't try that, that's because I want to just go ahead and put my not guilty plea in. My not guilty vote in. I'm gonna just be honest with you. That's how I think. I am not gonna sit through all of this, be in this position 100 days in, and don't believe your witnesses, watch you put in rap lyrics as evidence, and then turn around and find these gentlemen guilty. Not right now. I don't see guilty. So I'm 100 days vested to vote against you because I feel like you're up to something. And the evidence for me does not prove guilt. It proves that maybe they may have some charges, like an individual charges of wrongdoing. Maybe they on the corner or something and they selling and they do, but that doesn't mean to me that they're a whole gang and it's all racketeering. I mean, you just haven't proven that. And they caused this murder as a directive of this gentleman who wasn't there. Like on the word of somebody who what lies to stay out of jail. Okay. All right, prosecution. I don't know. Do you have a case? Do you have, I hope you have some evidence to prove. Come on, you gotta bring the big boys out, bring the big guns, because you're losing. You are slowly losing. And everyone's head's hurting. Well, my head is hurting. All right, so that's the T-tip. So what we here to do today? What are we doing today? YSL got every day of my life now. This is ridiculous. I'm in a minute that I need to get initiated if this is a game because I need some payout. This is absolutely absurd. Every single day we got court. We got court, we got filings, we got drama. Okay, so we know Judge Glanville is no longer the judge, and I hope he knows that. Oh wait, did I thank him? Let's thank the people. Thank you, 11 Alive. Oh, I thought I was subscribed. Let me subscribe. 11 Alive has been sending me some great coverage, so thank you. I'm gonna go ahead and give it a thumbs up. We're in status conference, ladies and gentlemen, because we have a new judge. We went through the judge round robin. It was like the Cupid shuffle. Who can who can avoid? No, it wasn't. It was actually appropriate. So as much as I was looking forward to Judge Ingram being our judge, it was appropriate for her to say, wait a minute, I have a potential conflict in due to the controversy between the deputy and one of the defendants. So that was a very respectable recusal. I think I'm gonna miss her. I think I'm gonna miss her because she came out on a good foot. So let's see what we got here in Madam Paige. You know, I love her name. So Paige Whitaker is taking on the status conference. Well, guess what? She knew too. I'm new to the case. She new to the case. So we start over. I don't know how much over we're starting, but we are finding out who's who. Okay. But you know what's interesting is this attorney seems to sit in various places depending on the day. I guess it's just the way he does, but usually you sit in the same place. Oh, and no, maybe he's getting ready to present something because I think this is their assistant, their paralegal, because I think I saw him before getting the exhibit together or whatever. I don't know. I'm learning the people too. So Judge Whitaker has taken the bench and she is now having her status conference. getting reintroduced. We're doing a proper roll call. We're finding out little bios, little elevator pitches as to who's who and what role do they play in this case.
Counsel is Mr. David Botts, who is
Oh,
also
one more thing. I found out that the doggone mics don't work everywhere. So I was like really mad at the attorneys for like not turning on their mics. I was like getting really frustrated, like, we can't hear you. They very well may not. So FYI.
here, and this next to Mr. Shaquille Kokomo. He has been working on the audio visual on behalf of some of the clients,
Okay.
including Mr. Stillwell. So he's
Oh, he's the audiovisual tech. He's the AV. All right, AV. Shout out to AV.
part of this case.
All right.
Shaquille Kokomo.
Are you an attorney or paralegal?
He's going to be a Boston school student.
Okay, well-
He's college graduate right now.
Fabulous. Good luck to you. All right. Thank you.
Good morning, Judge.
Good morning.
Carson Matthews Sr. here. I represent Marquavius Healy in this case. I also have
Oh. One thing to note is the clients are not there. It's a status conference, so clients can come because quite honestly, as a defendant, you are encouraged. First of all, you want to see everything. You want to make sure everything, you want to be able to witness what's going on to ensure that your attorney is not like drunk, sleep, forgetting law, all this stuff, right? But you also want to see what the other side's presenting, so you can help your attorney by saying, this is what I know that might help this or that. A lot of times it doesn't help. It just helps you to feel like you're contributing to the case. But sometimes it will help because it can be very helpful for the attorney to be, refreshed as to what is exactly going on. But they're not in here. And I think it has a lot to do with the fact that I believe all of them have been held for 2 years without bail. So it just might be logistically easier because the status conference obviously was set, real quick after she became the judge on the case, maybe 2 days ago. So it might just be logistically easier for them to hold the status conference without the clients. I don't think this is an admonishment to any of the clients, because some judges will say if the client's not here, then we will arrest them because they want them to be present for all the hearings. But I don't think this is one of those types of hearings.
Mr. Marquavius is my son.
He represents
Carson
Marquavius.
Matthews Jr.
Good to meet you,
who's
dear sir.
not here today, and also Attorney Teresa Mafu is also in my office, and we represent Marquavius.
Okay. And I had both of your names. I don't know if I have Miss Mafoods. Has she entered an appearance? Okay. All right. Well, we can update that. Okay. Thank you.
Guys, I'm about to cash a check for $180,000 and get my.
Hey, Mr. Bucks.
Good morning, Your Honor. Doug Weinstein, I represent Mr. Demonte Kendrick,
Okay.
along with my co-counsel Jay Apps, who's ill today, and Katie Christie, who's on leave.
Okay. All right. Hopefully Mr. Apt will be feeling better
Thank you.
soon. You can pass that along to him.
I'll do that.
All right.
Good morning, Your Honor.
Morning.
I'm Brian Steele, and I have the honor of representing Mr. Jeffrey Williams, along with the Honorable Keith Adams. Sitting next to Mr. Adams is a law student. He's a rising second year. John Marshall Law School. His name is Griffin Lail. Griffin. It's okay for him to sit with us. It would be appreciated. If not, he will obviously.
Is he sworn in under like the Third Year Practice Act or?
No.
All right. So I guess he can just act as a paralegal for now. Okay. Good to have you.
Good morning, Your Honor.
Good morning.
Okay, I don't want paralegals hurt. Don't be hurt. He's a third-year law student, so clearly he's gotten a good grounds for criminal law and civil litigation law and procedures and stuff like that. So don't get hurt. He's got his torts and contracts all done, and so he's in court to act as a paralegal. He's not certified, but it's okay. He has enough lawyering education, if you will, to kind of sit there and at least absorb what's going on. He's actually there to learn, but she's placing him in the paralegal status because the way it works is you have to be licensed or you have to have I don't know, maybe he's not third year, maybe it's the second year, I forgot what he said, but you have to, in your third year, you can get an exception to be a participatory, unlicensed legal aid of sorts that you can, participate in the case and in the trial. He won't be able to do that in this juncture because he is not yet that far along in his education, or he doesn't have the exemption. So that's what she was saying. But don't get hurt. It's okay. He knows some things. I know a certified paralegals with 20 plus years of experience. Like, wait, excuse me, you're just going to deputize him. You don't even get his credential. You don't even know what school he's going to. Don't worry about it. It's all right. 2-3 years, he's good.
We got lost here. Mr. Reveal's Ryan. I am the secretary to Ms. Angela Williams, who's ill today. I think she's sending a Zoom link.
She should be on Zoom, and I guess I should get on the Zoom as well. Give me a second to do that. Okay.
She has to be council lines in a second before.
All right. Ms. Rossler and Ms. Bushfield, will I find a Zoom link on my calendar or?
We are
Okay.
just formalizing
Give me a second to
ourselves.
get on there.
Just trying to get
Well,
acclimated to all people in person and technology that's supposed to happen. If
We
start all the
tested
way
everything
over-
yesterday, but of course the computer is not wanting to cooperate.
We actually, we don't have to start all the way over because there is a court ruling, a statute in Georgia that says that the new judge can take the case up from where it stopped. They don't have to start all the way over with all the other evidence. So I'm presuming she's gonna take it up from which it stopped, but obviously it's day one, so we're getting day one vibes. We don't know where the Zoom link is. We forgot to, get our appearances and it's all right.
Can I just go through Zoom?
I'm here. Me too.
Trying to find
Me too. I don't know what's going on here either, Judge. I'm with you. And I love your name. So we connected. Don't fail me, okay? Please don't fail me because Zuma. Oh, Adams is here. I didn't see him earlier. I don't know why. I didn't see him. I heard his name, but I didn't see him. All right,
seeing
Adams.
her on the screen.
Oh, Your Honor, I'm here.
Okay, are you just not on video with us?
Right, but I'm here.
Okay, all right, well, good to have you. Hope you feel better if you might be sick as well, I think. Okay. Good morning.
We so need a mic. We need working mics in the defense area. And one of the main reasons why is because the mics in the prosecution area and the judges area are so sensitive. They work so well that every paper and shuffling that they do, it makes it hard for us to hear the defendant when they're talking. But look at the ponytail. We got braids and ponytails. Go ahead. We got rock stars here on the defense attorneys. Rock stars are representing
That sounds fine.
hip hop.
All right, so a couple of things that we need to try to figure out from the outset. What is pending that I need to make a ruling on, and what our schedule is going to be like moving forward. I know there are already a couple of weeks that the jury has been sort of told you'll be excused for this week, so I will honor that. But I need for us to try to be efficient with the jury's time. So whatever we all need to get sorted out in the interim.
Yes, Your Honor. We all need you to be efficient with the jury's time.
Before we bring them back as much as we can do. I'd like to do that so that we can minimize the times when they're here, but we have to send them to the jury room to figure out things that we could have figured out before. And I know sometimes that is going to be unavoidable, but to the extent we can avoid it, I'd like for us to talk to each other beforehand, give each other a heads up about what is going to be coming in or what we think might be an issue and deal with it without the, wasting jury's time, basically. So Mr. Steele, on behalf of Mr. Williams, sent me yesterday a list of what he believes to be pending motions that still need a ruling.
Yeah, we have motions, but I have no patience. I have no patience for these ads. I have no patience for the advertisements. I have the advertisements. So guess what? This reminds me, like, share, and subscribe, okay? Put a comment in there. We can disagree, be respectful, comment, it stays. Disrespectful, it goes. All right. So that's how easy it is. We don't have to agree, but put a comment down. Want to hear from you. What do you think? You feel like you're brand new to the case, starting all over? How you feel?
And I think I have one that I know of from Mr. Huey, and I'm just going to kind of hear from each party as to what, as the state as well, as to what y'all believe is pending that we need to get heard. And since I've already got Mr. Williams' motions written down, I'm just going to make sure, Mr. Steele, that I've got all of the ones that you believe to be pending. So I saw in your email a July 8th and a July 9th motion to recuse both Judge Glanville and Judge Krause, which I'm obviously, we're not going to do anything substantive here today. I'm just going to make sure I know what y'all believe to be pending. A July 10th motion entitled for a fair trial that is essentially to find out about whether there have been any other ex partes. A July 1st motion that's kind of a proffer about something that happened with a jail call, evidence that's already been taken care of. And I mean, I'll look back into that. But a July 18th motion to disqualify 2 of the prosecutors. A July 10th motion asking, I guess, prospectively for a fresh look maybe at 24-8-801. And then you had also provided an amended witness list and a notice of filing. Are there any other pending motions for Mr. Williams that I didn't include?
It's not a motion that filed. May I address that just for your edification?
Sure. And are you going to file it? You're just giving me a preview, or?
Okay, so Mr. Steele is talking about there is a motion that he plans to file or something that he's going to file that's not yet in the docket. And so he's putting on a new motion. All right. What's up? What's up, Brian?
I can file it.
Okay.
I'll do whatever the Sound Court desires. So I just want to bring to the court's attention to be fair to the
Okay.
court. May I approach, Your Honor?
Yes. And it may be easiest to just hand it to Ms. Pursfield. And y'all, it's on my mind right now. Before we all leave here today, I want to make sure that my staff has cell numbers for everybody. Okay. All right.
So I've handed this honorable court's coworker and the state, 2 cases, PROPST versus Morgan, MORGAN, and it's 288 Georgia, 862, 708 Southeast 2D, 211. And if you look at page 2 of the copy of the case that I've handed to this honorable court and the state, on the left-hand side, on the bottom last paragraph, our highest court explained that another line of appellate decisions holds that if a party files a motion to recuse a trial judge and the motion is denied, but it is later determined that the judge should have been disqualified to act in the case, all proceedings after the filing of the motion to recuse are invalid and have no effect. And the reason I raise that is, Your Honor may be aware but may not be, the Honorable Douglas Weinstein filed an initial motion to recuse Judge Glanville. He did that on June 12th of 2024 in the afternoon hours. Judge Glanville initially he stopped proceedings and he denied that motion without referring it to another judge, and he made some findings of why he's denying it. On behalf of Mr. Williams, the Honorable, yes?
Was there a written order?
He did file a written order
June the 14th.
Okay.
2 days later.
All right.
And that was the Honorable Douglas Weinstein.
Okay.
The Honorable Keith Adams and I, on behalf of Mr. Williams, then filed a motion to recuse, but we didn't file ours until June 17th. It's Monday, June 17th.
Okay.
But the way I understand the case law is that once Attorney Weinstein filed that motion, which the Honorable Judge Krause eventually granted, Judge Krause in a written order dated, I'm going to tell you.
Okay, so here's the thing that I have issue with relative to this part. I understand Brian Steele, but I want to know what the rest of the law says, because when the order came through to actually recuse Judge Glanville, in the end, it wasn't because of the ex parte hearing. It was because of a technicality of him defending his actions and quoting the law and talking about cases. That whole like soliloquy he did was what we call argument and defense. So he defended and argued his position. And the law in Georgia states that once a motion to recuse is on the table, you cannot, basically you have to stop and you have to take in consideration if it meets the 3 markers that Judge Krause said that it did meet. It was filed timely, meritorious, and so forth in the affidavit. If true, then the result would be recusal. So consequently, it needed to be taken out with another judge. The first motion, Glanville did not do that. So consequently, we got into the whole kerfuffle about getting it done, basically. My position at this time, my concern at this time is that, because Ben is like, Brian is saying, hey, he should have been recused the first time, because he eventually was recused for his actions. But it wasn't. The order, this is why I said the order was like a love letter. It was a washing of the hands. You have to really go through that order word for word. So many people have not, and news outlets have not really taken it up appropriately. They're acting like the order to recuse was because of the hearing in and of itself, or the actions done in the hearing. That is not the way the order reads at all. The order excuses the actions that were done in the ex parte. The order promotes that Judge Glanville could very well still maintain on the case with impartiality. However, since he argued during his, I'm going to send this over to the randomizer, he began arguing and defending himself, he went into another tier, which is something that was allowing Judge Krause to recuse him. And this is why I say it was, to me, more like a gift and a love letter, and that she should have recused herself, because what it looks like, the appearance of it, and that's just my little bitty opinion, just a little bitty on me, it makes it look like you didn't want it to go outside of the circuit as it was requested, because you wanted to make the order and you were like, no, I'm impartial enough, because you knew you were going to order against, you were going to order for him to be recused, but you were going to do it on the technicality so that you could wash his hands of the actions. And so consequently, this factor here that Brian is getting into, to me, it has to do with, if your actions were improper and you're recused for the actions, then therefore, we get into this place where we have a problem. However, I'm just concerned, does it also include the fact that the order that he was recused upon was because of the technicality of his argument, not necessarily because he misstepped in having an ex parte hearing, going through Brady violations and different rights of the defendants. So that is where I'm like, oh, it would be so great if she had really ruled on the facts that were presented to her relative to ex parte. I mean, she did say what he did was may have benefited to be in open court, but it was not problematic. Like it was like it would have been good for it to be an open court, but it was no big deal. I don't agree with it, and you can go through my video on that. I have that extensively noted in the, because we went page by page, word for word, in the ex parte motion order by
July.
Krause.
Krause.
But this is where I'm like, oh, this is where I'm like, Brian, you know you're my favorite attorney. You and Ben. Like I can't even get Ben's last name anymore. I got Ben Steele is one and the same right now. We got we got Ben and Brian Steele. I can't even think of what is Ben's last name from Deputy Hurt. Anyway, my two favorite attorneys right now, as far as a good lawyer, and a Camille Vasquez. Okay, of course her, and then the people I know. But these are people I don't know. So I don't know, but oh, and then Alan Jackson. Now that he's on the defense team, I kind of like him, but I don't think he's gonna win either. My people are losing. I think we're down for the count. It's gonna be sad to see what happens in the Karen Reed trial. All right, what's going on, Mr.
Krause eventually granted. Judge Krause in a written order dated, I'm going to tell you, July 15, 2024, granted Mr. Williams as well as Mr. Kendrick. Mr. Weinstein represents Mr. Kendrick, both of the motions. So the way I understand the case law is everything that happened after the filing by Mr. Weinstein on June 12, 2024 is invalid.
Okay. So if you would do me a favor and put that in writing and file it as a motion, and then I will add that to our pending list. And I appreciate you letting me know. I don't want to get into substantive argument about anything today because we don't have the parties themselves here. This is basically just a sort of status. So if you will file something to that effect, then I'll have that added to the.
So Brian's objective with this motion is saying all other things after that is invalid. I don't even think he cares about his own motion at this point. He's just like all other things. And what was one of the main other things? Copeland was on the stand. It's invalid. So, I mean, heck, Copeland is still on the stand. He's not there, but he's still a sworn in witness. So, you know, everything he says relative to this case needs to be in the witness box before the prosecution, before the defense, and in judge and jury. Okay.
List, but I appreciate that.
Can I add one other thing just for your knowledge? But
sure.
If it's something that's more than a status, then I will withdraw it.
Yeah, I mean, you can tell me, but I'm, not going to consider it. We're not going to argue it. But yes, absolutely. Go ahead.
Understood. I just want you to know that there was a witness testifying. That's why I thought it was important, which will potentially, if you determine it, require the jury to have their notes, if you require it taken away.
Yeah, put that in the motion, Brian. That's what she needs in the motion, that if all things are invalid, that includes the witness testimony. Mr. Ace Boone Coon #1, Little Woody, right? Like, this is, yeah, so we'll see.
And then wiping out what they heard. I just want you to be aware of that.
Okay, I'm not sure if I follow what you're saying now.
So there was a witness testifying. His name is Mr. Copeland.
Yeah.
After Judge Glanville denied that motion, the jury heard from a witness on the afternoon of June 12th, June 13th, June 14th, and then June 17th. So I just want.
Look at Miss Love. ADA Love, you're doing so great. We got to clap it up. We got to give her props. Listen, if I don't want to besmirch anyone, so I got to give it up to her today. She is in her right position. First of all, I'm not even talking about the chair, but she's not rolling and hipping. She usually gets her neck going and shaking, and it's just so distracting. But she might be on the understanding that she's before a new judge. It's just to build up her rapport with the new judge. We shall find out. Not quite sure what's gotten Ms. Love on the right foot, but I'm loving the fact that she has kind of calmed down. She did do a little roll, a little, no, but that's okay. But the other outlandish body language that she does is very distracting. So I want to give her kudos for staying calm, even though Ben is telling her your main witness is not worth a dime.
Okay. All right, I understand what you're saying now. All right, thank you.
Other than that, those are the motions.
Great. Okay. For Mr. Huey, I have got a renewed motion for bond. Is there anything else for? I don't even know which party I'm looking at yet, but,
Again, Your Honor, Matt,
okay.
senior for Ms. Huey. That is the only motion that I've
Okay.
at this point, Your Honor.
all right. Yes, thank you. Okay, so, for Mr. Stillwell,
Okay, so this is, looks like an Airbnb, and
Like,
it looks like people are just
for
walking.
real. For real. We haven't been played a minute and there's another freaking commercial. Like, share, subscribe. That's all I can say. Like, get out of here.
So, Your Honor, the way that we had been operating under this case, under Your Honor, Judge Glanville was. Yes, sir. Your Honor, the way that we.
The mic works and you're opting not to use. Do you know how important this case is to YouTubers and LawTubers and law students and all people who are nosy? What? We need you to use the mic. If the mic works, work it. Dog it, we can't hear you.
We had been operating under Judge Glanville was a thing we named the Harvey Rule, which assumed that all were in agreement and opting into a motion unless we specifically opted out of the motion. So
everybody has joined on everything.
Appeal has filed a number of motions that we opt into.
Okay.
And Your Honor, I'll also just point out, there's also the gentleman who's on the stand right now. I think that we need to have a hearing regarding the admissibility of his testimony. I'm not looking at Mr. Steele's motion, but I too believe that we need to look at the co-conspirator exception to the hearsay rule and determine if that applies to the gentleman who is currently on the stand and what he said.
Okay.
And additionally, after Mr. Weinstein's recusal motion, we spent a significant amount of time going back and forth about prior statements and redacting prior statements. And I believe that
Prior statements of Mr. Copeland. Okay.
we would have to go through that process again because that was done after the Mr. Weinstein's recusal motion. So we probably need to relitigate that as well. Of course, if it doesn't fall under a hearsay exception, then we wouldn't have to do that. But
Okay. And with regard to the question of the admissibility of Copeland's statements under the co-conspirator rule, is there a pending motion or was there an oral motion? Has there been a ruling?
there was a ruling.
Okay.
I don't recall if it's been reduced to writing. I'm going to assume it was. But you know, we've litigated a recusal motion. We've talked about the appearance of impropriety at this point, and from our stance, we need to relitigate that issue.
Okay. Yeah.
So he wants just to start over relative to Copeland. And Georgia's co-conspirator hearsay rule, I looked it up, is 24-8-801. And I think it's sub D to E as in Edward. But basically, it just means that if a statement from a co-conspirator is deemed hearsay, and that statement is offered by the co-conspirator, it's not admissible just by itself. There needs to be corroborating evidence to the statement. And so that's why he says we're arguing admissibility of Copeland's testimony because he's a co-conspirator and he has some hearsay statements. And so consequently, without supporting evidence, it shouldn't be admissible. That's what he's not arguing. He's saying this should be another motion to argue. They are coming together to find out what should we be talking about. Motions or like what should we talk about to make sure that we're covering all of the legal aspects of the case. And all the defendants are like, we got 5,000 motions, and I want to add another one, and another one, and another one. DJ Khaled, get your money, and another one, because they are. Brian just added one, saying that Copeland is completely not even to be considered at this point because the original motion for recusal was denied. And as it came back around, it was granted. So consequently, things from the original time frame is how far back you go as to what is erased from the record, basically. And that's Copeland's testimony. Then this gentleman who hops around a little bit, he says, like he's usually like next to Brian's camp, but now he's over here in the corner. He says, and I want to add that we have a co-conspirator hearsay rule for Copeland's testimony because so therefore it should not be admissible under those grounds. So these are motions that they want her to take up consideration and make a hearing for later.
I mean, Sure. Separate from whether anything needs to be reconsidered based on anything about the recusal, just with regard to like pure evidence. Was there an objection and a ruling
There was. It was.
before he started testifying?
There was.
Okay. And that's what you're saying?
There were lots of, Your Honor, where have you been? Listen, this is amazing. The whole wide world is zoomed in on the YSL case. Everyone is trying to figure out what the heck is going on in Georgia, except for people in Georgia. Good job, Georgians. This honor is like, I don't know nothing. And the jurors are like, yeah, we don't know nothing. Every time they come back, like, we haven't heard a thing. Georgia is keeping the news out of the news. Good job. I mean, I don't know how you don't know this, but like, there's gazillion objections. Pick one, and that one will set every time. Like, you just pick one.
Should be.
Pick one you like.
But is that what you're saying should be reconsidered? Okay. All right.
Check this out. I'm going to show you how I can afford this.
We want to reconsider why we are being spammed. There's no reason for this. We have done nothing wrong. Stop trying to sell us stuff, okay? But you know what's free? Like, sharing, and subscribing. Those things are free. Comment free. And it's freedom of speech. So go ahead, comment, do your thing. All right, there's our commercial for the moment. And let's see what's up.
All right. I am not going to go back. I mean, this case has been going on for how long? 6 months, at least the trial part of it. And obviously I'm parachuting in and I'm just going to have to pick up from here and move forward. I cannot go back and reconsider every evidentiary ruling that's already been made. And I don't think that's what you're asking. I think you're saying because this witness is still on the stand. But I don't know, Mr. Botts, if you were about to say, let's reconsider everything, but we're not going to be able to do that. On Mr. Copeland. Okay. All right. All right. And let's see, for Mr. Ryan, and I understand everybody's basically joined.
That's what, Your Honor. It's okay, because the case didn't start until Copeland hit the stand. Like, that witness is the witness. Like, everybody's knowledge of what's going on is on him. He is the source of it all. So if he don't work out, the star witness doesn't work out, we don't have a case. So, you don't have to go back any further. Just figure it out if he's admissible. If he's not admissible, then hey, we can maybe move on with our lives.
And on everything we've already talked about. Is there anything that's individual or in particular to your client that I need to think about?
Okay, I'm gonna slow it down. You guys may not.
Hopefully the state will correct me if I'm correct. But what specific evidence the state plans on using for witness has been specified somewhat on a bowling basis.
Okay.
I'm going to give an example. This is my case. There are 15 recorded interviews.
Mhm.
The state is not necessarily going to offer all 15 within the.
Okay, so she's not, or the mic is not helping her. I'm not sure what the issue is, but sound is not her friend right now. And what I hear from her is that, and it sounds it's like a great salient argument to me. She's stating, what I hear, what evidence are you going to reconsider? Understanding that you're not going all the way back to the beginning because it's 6 months of trial and 18 months of everything, whatever it is. 2 years of life, 3 million years, we don't know. It's forever, right? What are you going to consider? So we know we got Copeland as if his testimony is admissible, because that's been brought in through Steele, and now we got Steele actually said everything in that moment on. So he brought that in from recusal. Then he brought in Steele, the other gentleman brought in because he had testimony before the motion to recuse. So there is some testimony of Copeland beforehand too. So he's like, no, Copeland altogether is inadmissible because he's a co-conspirator, so he's out. Fuck him. So she's saying, so we got Copeland as the issue. But there's the tapes that are the issue. And we went through that maybe last recording where Brian was like in the motion for fair trial. He's like, hey, look, check out YouTube because I got problems. We got problems because one of the instances that he has the motion to say that it's not a fair trial because Judge Glanville ruled against him being able to play the whole, I guess, music snippet or Snoop Dogg snippet, whatever it was. It has to do with some music piece. But the reasoning he decided that it was admissible was because prosecution was reading line for line. And on direct, until you can establish that your witness is hostile, and I don't know if that was established, I didn't see any part where it was, but when you're on direct, you're not asking witnesses yes, no questions, you're asking them open-ended questions, like, so what happened? What did you do? And then what? And why? And where? And who? Anybody else? What else? Something else? Nothing else? But you're not coming around with, okay, so did you say, the rap lyrics said, did you say, I'm gonna shoot your mama on 55th Street? Yes, I did. Did you say last week it was all about the gang street? Yes, I did. You know, that's not direct examination, that's cross. Cross-examination is yes or no question. So because not only was the prosecution being they were inappropriately asking the questions, because when you ask the questions that way, you're actually just ringing bells that can't be unrung. Because in the jury, I mean, unless you just spend 100 days doing the trial, right? And then maybe they forget. But in the jury's mind, it's like, yeah, they was talking about killing somebody. They was on 54th Street killing somebody. Oh yeah, it was a song, and she was offering it for the truth of the matter. Character assassination kind of feel like, you know, these are bad people because this is what they rap about. This is what their art is about. So Steele was like, well, if you're gonna put in pieces and cherry pick these words, because the truth of the matter of the song, the whole essence of the song is, I've done bad things, but I've learned that they're bad. I've paid my price, and I don't want to do it again. Or don't you do it? Don't you go down this road? So it was meant to be like a positive setting, but they're only cherry picking the admissions or the thought process of doing bad things, if they in fact did them. Because like you say, it's art. And what are you going to do when AI is writing the song? You're going to put AI in jail too? Come on now. Come on now. And what about Pac? Pac didn't know Brenda. That wasn't his baby that was in the trash can, but that was a real thing that happened. Brenda was a real person. Brenda had a baby, and the baby she did throw away. This was real. It happened. And that's why he put it in the song, because it happened and the community wasn't getting much news coverage of it. So he put it in a song. So I'm sorry. So we're going to dig up Pac and put him in jail? Like, this is why I have a problem with this case, bringing in rap lyrics. Their First Amendment rights, their artistry. Sometimes the realness of it is not your truth. It's a truth that you're telling from a different perspective. Now, Pac had the good sense not to say, I didn't put the baby in the trash can, but there are some rappers we know ain't done a lick of nothing, and they show rap like they do. You know, dare I say colonizers? But anyway, anywho, I'm gonna get off that soapbox just for a minute. Get back to this case. So, young lady here, fabulous lawyer, second chair, is being very poignant. Your Honor, what will you consider? Because we got songs, they got problems. And one of the things is they had 15 different songs, but yet they weren't bringing in 15 different songs. They were only bringing in portions of the song or snippets of the song, and the essence was getting lost. And Brian Steele's motion got overruled because he wasn't allowed to bring in the evidence, full evidence. It's like we have an evidentiary problem because you're bringing in evidence and you're not giving it giving the true light. You're not telling the truth about it. All right, that's what I have.
There are parts which are inadmissible. Everyone would agree they're inadmissible, but the state has not had a chance to sit down and specifically say, we want these statements, and here's what needs to be redacted, and go back and forth on that. So we're not cross that bridge yet, Mr. Ryan. When we do, you'll have motions of that nature.
Okay, so I'm going to try, and we can maybe get to that in a minute, but I would rather everything that should have been a motion in limine get sorted out. I don't care if we're 2 months from that testimony. But
that's absolutely fine.
yeah.
So for those who want to correct my pronunciation, are you going to correct this judge's pronunciation? Because it's not motion in limine, it's motion in limine.
Well, to the extent we can stop that,
right?
we're going to try to get everything done beforehand, but we'll see. We'll see. All right. Thank you. And then who else have I still not heard from? Mr. I will, y'all, in a couple of weeks, I'll know all of this, but I just honestly have not been following this case up until now. So, Mr. Harvey, for Mr. Nichols.
You.
And I may need you to yell.
I'm sorry. Better?
Yes.
Per the rule we've been operating under, we're all in on everyone else's motions.
Central High School, how may I help?
I am not into these commercials. Not in for it. We don't need this many. You know what to do. You like and you share and you subscribe. You did it already. Tell them it out. We don't need any more commercials. Okay, so this is the all-in proffer. Yeah, we got it.
Everyone else's motions, barring a on-the-record opt-out.
Okay.
So we're in on everything because we have not opted out as of this point on any of those motions.
Okay.
There may be, to be honest with the court, I wanted to see where we were today, what our plan was. There may be some additional motions that would be filed on behalf of Mr. Nichols and perhaps other defendants. If we're going to view this as sort of a logistical status conference, based upon prior proceedings, we've mentioned certain things. We've mentioned certain cases about what may or may not be valid or evidence post motion to recuse. There may be some additional motions that need to be filed. So I would ask that on behalf of Mr. Nichols, that not only we're opting in and we need to now think about whether or not there's going to be any specific opt-out, but to give us some time frame to file any additional motions based upon the unusual proceedings and circumstances in this case moving forward.
Okay, I'm confused. The judge is going to make it plain, but I just want you to know why I'm confused. So a motion becomes a motion when it becomes evident you need a motion. So if the trial is going on, now except for motion eliminates, those are supposed to happen prior to, because you know what evidence is of issue. So you've dealt with most of those. And I think the other young lady's point about we're not sure about some of the evidence because the prosecution is still going through what parts will be in and what parts will be redacted. So we're still going back and forth on them. So we may not have to have motion eliminates, but whatever. And that's when Madam said, okay, well, we'll get to those motions later. That's understandable because that's evidentiary motions to keep things out of the trial. And there's certain evidence that has not been decided upon amongst the parties. So therefore, they really can't they can't put up a motion to say, well, no, this is improper. I don't understand his question because what do you mean? Why are you looking? I don't understand why he's looking for a motion cutoff. This discovery is already done. She's coming, like she said, I'm parachuting in. I'm coming from the point from which you stopped. And the only rewind that is happening is according to Steele's assertion relative to the case law that, from one point, we stopped from one point, but actually we stopped back here. So we gotta really determine where we actually stopped from. And then once we figured out where we stopped from, we've got to erase. And that's what he's talking about when he says, we got to go backwards a little bit. And then the other guys are like, well, truthfully, we don't need that guy at all because he's inadmissible.
All right, so I'm not going to be able to give you a blanket, hey, you get X amount of days to file whatever you want here, because I don't know what it is that you might be contemplating. And frankly, there have been, at least a week and a half that's gone by since whatever the ex parte was that caused all of this. It may be that it's appropriate for another motion to be filed and be considered. It may not be. I'll kind of have to wait and see.
I mean, just refile the whole motion. You know what you should refile? You should refile the motion to recuse the prosecution because that was not decided upon in the order. And that would be a good refile. That would be a really good refile because the order does not address the ex parte hearing as being improper, even though with the Brady violations, I feel like it was. And then the factors that emergencies that was supposedly asserted to having the reason for the ex parte were really not sifted out and determined on record, at least. Because I find that there are missing pieces of this record, but nonetheless, with that being said, Your Honor, yeah, I think we should refile that one. Let's refile that one. Good job. Okay, so I forgot his name already, but the ponytail and the braid, I'm loving. Good job. You got it.
Sort of what it is and why it is only now that it is going to be filed. So I just can't give you an answer on that before I know what it is. But I mean, I'm certainly not precluding anybody from filing. I just don't know if it's something that could have been filed 10 months ago, then I probably don't want to hear it now.
No, I think these circumstances are unique, clearly. So it presents unique.
People ask me all the time, Chris, if you could only take one supplement for the.
Chris, if you can only just not interrupt court, that would be great. Because I don't need this mini commercial. I wouldn't even want to monetize if this mini commercial was on my stream. I think everybody would jump off, right? So cut it out. It's not
unique, clearly. So it presents unique opportunities to now move the court. Now that we have a court, I just
okay. So why don't I just say that if you are contemplating anything, contemplate it quickly and get it filed.
5 business days.
Smile, yes, quickly, please. Very quickly. We don't want to be here long. I think this is her clerk and this is her court reporter. I think, or maybe it's the other way around. But I do know that she gave a nice smile like, please, quickly. Yeah, we need this quickly filed so we can quickly move on and quickly get into this so we can quickly be done. I love it. But yeah, I think he now that I've kind of talked out loud and thought out loud and dealt with his questioning, I think one of the major filings that needs to be clarified is the recusal of the prosecution for stuffing Little Willie in a closet and making him testify. It wasn't a closet. I hear that the chambers are big and lush, so it was very nice.
Yes, before the end of next week, because, and I want us to all look at a calendar in a few minutes, but, the jury has already been given the week of July 29th off, so they won't be back before August 5th, really. So I would like for us to, if we're going to be moving forward with this case, to be able to move forward with it and have all of whatever this is going to be out of the way before then. So if you can honestly, because I would also like a response from the state on anything that gets filed. So if y'all can, given that you've had already, a week and a half since whatever went down. I don't know the exact dates of everything.
I would object to that. So here's the thing. My theory is you refile the motion for fair trial and the motion to recuse ADA Love and ADA Hilton for the factors of the ex parte hearing, right? And obviously she wouldn't personally be able to take it up, but she would have to take up timeliness and so forth. I would pre-file stuff like that and then see if we can get that moved along, because in the order, it doesn't really go into proper and improper dealings. It kind of washes and says everything was fine. And it doesn't talk about ADA Love or ADA Hilton's role in the ex parte hearing. But to say, oh, you've had so many weeks, no, the order just came out on the 17th, right? The order for recusal just came out on the 17th. So you didn't know what Judge Krause was going to do. And so she did it, and she did it on the 17th. Today is the 19th. That's only 2 days ago. So I would start objecting and saying, just clarifying for the record, we actually have not had a week and a half because we've been spending this time trying to get a order, all of our orders answered. And, the judge didn't do it. She answered one thing, very technicality.
Yeah, but
just 2 days ago.
You don't really need 5 more days to think about it. I'd like y'all to get anything that you're going to filed by the 23rd, which is next Tuesday. That may make for busy weekends for y'all, but that is what it is. And then I want responses from the state by that Friday, the 26th. Okay. Which does not mean I'm inviting them. It just means if there are some necessary ones that we need to consider. Obviously, I want them briefed by both sides. And then we'll probably spend the week of the 29th we'll all be here without the jury trying to get as much done as possible, I think. Okay.
And that may answer my next question. I know that on behalf of myself, and I know various other co-counsel, as soon as the words "we're in recess" were uttered, I have emails, special set trials. I am inundated by other, both federal judges and Superior Court judges. I am asking for protection, and I would assume that I know that on behalf of myself, and I know various other co-counsel, as soon as the words "we're in recess" were uttered, I have emails, special set trials. I am inundated by other, both federal judges and Superior Court judges. I am asking for protection, and I would assume that our co-counsel would join in this protection so that I can say to these other judges, I am on trial. I'm required to be participating in this court, and you cannot set me for trial in another court because I'm on trial. Can we get that protection?
Yes, you shouldn't even need that because we are in the middle of a trial. I don't care whether the judge has changed or not. This trial is ongoing. But yes, to the extent that any judge calls at my chambers, yes, I will tell them, sorry, you can't have Mr. Harvey right now. I've got him.
I want to make those representations in conflict letters. I want to make sure that I'm doing that properly.
Yeah. Now, if there is, because I have been until recently one of the people trying to get a hold of all of y'all for other cases. So if we decide we're taking a 2-week vacation in August, which we won't be, but hypothetically speaking, and y'all aren't in here with me litigating something, then I'm probably going to say you're available, not for a trial, but for, a 1-day hearing or something.
Yes.
So this availability is when the attorneys are on assignment. That's what his protection is for. So unlike Mr. Steele, who's a private attorney, he is in charge of his own calendar, his own docket, if you will, his own, caseload. And he's probably referring it out to his friends, and everyone else is getting great money because they're getting all these great referrals because he's too busy to take on cases right now. But nevertheless, if he has other associates, they're probably handling some of his cases and so forth. This gentleman is appointed, sounds like, by the court. And so what happens is we saw this in the hearing with all the defendants and not enough attorneys, because the judge is like, listen, you don't have that many defense attorneys. So, you don't like this one, you can't get a hold of him. We gotta find you another one, whatever it is. And one of the clients is like, I'm gonna pay for my own. I said, well, that's fine. So you can afford to pay for your own? Because we would love for you to pay for your own. We don't have enough attorneys. And this is evidence of that, because we have appointed attorneys for the defense being most likely paid by the state. And they're on this case already. And there's other judges that are like, hey, I need you to do this for this defendant. Hey, I need to assign you here. And hey, I need you to assign you there. And he's like, okay, we were on recess, so I ended up getting assigned to a couple of hearings or whatever. But I need proof that I'm back in court so that I don't get reassigned elsewhere. And she's like, yeah, of course you're in court. We're in court. We're not on vacation though. Don't take a vacay.
So
Come on.
I don't mind the one-day hearing. I do mind going to trial when I'm on
Sure,
trial.
yes.
So with that,
Y'all are all protected from being expected to be in trial anywhere else until the end, completion, however it completes, of this trial.
thank
Yes.
you. Thank you.
All right.
Ooh, let it be fast, Your Honor.
Your Honor, Doug Weinstein for Mr. Kendrick. We have no pending motions other than what has already been stated by our
Okay.
defense counsel that we all join in. We will be filing motions for Tuesday, but we have no pending motions. And you said we are going to discuss calendar moving
Yes,
forward?
yes.
Okay, I have some comments with regard to that.
Okay. All right. All right. Turning to the state, are there pending motions by the state that need a ruling?
Thank you, Your Honor. There are, and we will have to the court before Tuesday of next week, as the court has made a deadline. There are responses to recent filings by some of the defendants that the state anticipates it will be making. And there are 2 anticipated motions in limine that we will have filed by Tuesday.
Okay.
Based on the court's earlier instruction today, there were matters that are more appropriately placed within a motion that we will have to the court by Tuesday as well.
So what's commercial too? Gotta love it. ADA Love says motion in limine as well. And we say motion in limine, and some people say ex parte, ex parte. It doesn't matter. I don't care how you say it. Just spell it right and know what it means. As far as I'm concerned.
There are, and we will identify all of the ones that we believe exist. There are outstanding, there are rulings that have been made long ago by the court that may not have been reduced to writing. We are working towards identifying each of those, as well as putting into a chart for the court a list of the motions and rulings that have previously been entered.
That would be fantastic, because while y'all all know what the rulings were, I do not. So yeah, a chart and some further information would be great. That was on my list as well. Thank you.
I just want to, well, I don't know how many paralegals are in Georgia. I heard that, just I'm sure on this case they're given some staff, but there are some criminal prosecutions that do not get staff, so they have to do like everything themselves. I mean, from one end of the file to the other end, whether that's copying or writing the motions, or putting things, typing them up in the right format, or doing the legal research. All of these other components that very well may be parsed out to various paralegals and or copy assistants, the attorney does themselves in certain jurisdictions. So hopefully ADA Love and Hilton have a team of people to help, because now they're in charge of doing a chart of rulings. And obviously they're going to be concerned for their rulings that, I mean, they should be concerned for all the rulings, but they're going to be majorly concerned for the rulings that have helped their case and, will be beneficial to their client or to the state. So very much to do. This is a lot of paperwork on a 100-day-old trial.
Of course. And we also intend to address, we can do that in the context of a motion, or the court, if it is appropriate today, can address it. We would like to present to an exchange with counsel for each of the defendants what we believe and what we have kept a record of, all of the exhibits that have been tendered, ruled on, and admitted so far.
Okay.
If that is more appropriately addressed in a motion, I can do that, or if the court will permit us or schedule for us a deadline by which to.
I'm sorry. I can't even let her finish her sentence. Can all criminal attorneys let me know, why would the prosecution, and I guess this might be just because it's something new and different from one trial, from one recused judge to another judge, that might be where the difference is, but why would the prosecution be in charge of admitted evidence and or exhibits because it's already admitted. So the previous court reporter has the admitted evidence and exhibits. So they're the ones that should be producing to the new court. Here are the pieces of evidence. Here are the exhibits that have been admitted. That would be more in line with my thinking. And I don't know, as a defense, I don't want to sit up and waste time or start charging my client this extra time to go over your exhibit list. But there's no way in the world I'm going to approve your exhibit list without going over it. So why not just pull the ones from the admission that the court has, the admitted evidence that the court already had? I mean, just because Judge Glanville was not our favorite, or it just wasn't his favorite moment, does not mean his clerk didn't know how to keep evidence. Why are we now all of a sudden saying we have to figure out evidence? So let me know, put it in the comments, because this is weird to me. Why is she doing this?
Ruled on and admitted so far.
Okay.
If that is more appropriately addressed in a motion, I can do that, or if the court will permit us or schedule for us a deadline by which to exchange exhibit lists, because the state currently has an exhibit list that we believe is thorough.
Okay.
That includes the exhibits that have been tendered and admitted by both the state and each of the defendants.
Okay. And do you have that like with you and ready right now?
No, we want to present that to the court.
Okay.
We want to compare it with, if the defendants each have one, compare it with those. We want it to be as accurate as possible before we present it to the court.
Okay. So do y'all want to maybe, it sounds like outside of a proceeding, y'all all get together and do that? Or, I mean, if we want to all do it in court, that's fine, but it's not a bad idea.
I would have preferred that the court just order that each of us present to the other.
It is a bad idea. I mean, I just don't see the good idea. To me, it sounds like extra time. And to me, it sounds like extra time so the defendants can slow down from these motions they got to file. Because it's only one set of prosecution, but it's like, what, 6 defendants? So, and I think 5, maybe 1 is severed, 5, I don't know. The numbers are numbering and they're not, I'm lost, okay? There's people there and there's lots of them. And every time I sit around, there's a new motion. So are we saying that we're going to now take time to go back over something the court has already done? Why? Maybe she wants to slow them down. Maybe she's like, look, don't you file another motion. Look at my exhibit list and see if it's right. Pay attention to that.
The exhibit list that we have to the extent that they do exist, and that we then endeavor to.
Okay, so this is, looks like an Airbnb, and it looks like people are just walking through the kitchen, the living room, and they're not in.
Could be not on my stream. Yeah, could leave me alone. Yeah, could do a lot of things, but it won't, will it? You're making
iron out any differences or discrepancies. So that, for example, by next Wednesday, we each give to each other what exhibit lists that we have, not anticipated exhibits, but the ones that have already been admitted and ruled upon, because there have been moments where exhibits have been shown to a witness or spoken on, and the tendering party represented that the exhibit had already been admitted, and upon closer inspection, the exhibit had not been admitted.
Okay.
So we are asking for a date from the court.
Okay. So when can you have yours ready to dole out to everybody?
We can have ours ready by Tuesday if we can exchange them by Tuesday.
Okay. Is it, I assume everybody's been kind of tracking this. Could everybody have what you think is the state of the evidence by Tuesday?
I don't think that's going to be hard to do if it's okay.
I mean, frankly, whatever the court reporter has is what's accurate. So it might be that I can just get that.
where have you been for 5 minutes? I've been sick for this. Like, the court reporter is the record keeper. We don't need to go for exhibit list. Really, I feel validated. Thank you.
List from the court reporter has is what's accurate. So it might be that I can just get that list from the court reporter and give it out to all of y'all. And if there is that might be a better way to do it. And then if there is a discrepancy and anybody believes that's inaccurate, we can take it up. So why don't I talk to and we're going to be from now on, well, y'all all know Ms. Parker, but Ms. Parker is retiring in 1 week. I will have a new court reporter, and I know. It's the end of an era, but I'll have a new court reporter, Ms. Winfrey, who probably a lot of y'all know anyway, and she'll be moving forward. I'm going to ask Judge Glanville's court reporter to start working on transcripts, because I'm going to need them, but we'll all need them at some point probably, because just transcribing what's happened so far is going to take months and months. So we're going to shift not only judges, but also court reporters. So I will get with Judge Glanville's court reporter and ask her to give me a list of what has been tendered and either excluded or admitted or is still hanging out there. Give that to all of y'all, probably just through email from Ms. Rosser. And then if there's any discrepancies, y'all can let me know that, okay?
That would be great. Does the court, and I understand that there's really no way to tell accurately, but does the court have any idea of when we could anticipate receiving something
I
like
think
that?
pretty quickly. I mean, I've had a couple of communications with her already, and she seems pretty on the ball, and she's tracking it all on an Excel spreadsheet or something. So I don't think it'll take long. I think I can get y'all that by next week sometime.
Thank you.
Okay. Let me write my to-do list. Okay.
Okay, so let's just take a pause for the cause for a minute. Just real tight. Hold on. For every legal beagle who's like, yes, Excel spreadsheets still exist. I feel you, boo. We had ourselves a moment in the order where Judge Krause was like, okay, evidence is living on YouTube. So we're going to have, the record also includes YouTube videos. And I was like, wait a minute, this is brand new. And every Gen Z, X, and millennial was like, what you talking about? We do everything online. What do you mean? Like, it's about time y'all catch up. Law is slow to reach that type of updates, technically savvy, it's slow. Plus you got to think about the people who are the judges and the well-renowned attorneys, those who've been around for 20, 30, 40 years. So consequently, their way of doing things sometimes is way back then. What was it? The Girardi case where the guy, the main attorney who was like even on the board for the California bar is like, don't give me an email, like print it and put it in the file. And his whole office was like files everywhere. I mean, clearly that's a good way of hiding what he was doing. But two, those who are not hiding anything, they still, the older attorneys are still having files everywhere because we're a little slower to get to the technical age because we have a big fear of being hacked and those proprietary pieces of information floating in places they shouldn't, because we do hold very sensitive pieces of information. So I have e-discovery experience and certification. And so I'm telling you this because it was a big deal to get e-discovery passed and part of the structure. It's been a minute now. It's been about 8 years or 10 years, something like that. But in the beginning it was very hard. So, but for those of us legal beagles, yes, court reporter still has Excel spreadsheets. All right. We give it up for the court reporter in Georgia, holding it down for the more seasoned individuals in the legal field. We are not antiquated so far that we are dinosaurs. We still exist. We can still use our spreadsheets. Love you. Thank you. Appreciate the validation. So right now we're gonna take a little pause. I gotta take care of a little business. Got things to do, right? And life does things. Like things happen. You got to be places. And then YSL just happens to always be doing something. Like every single day. Like always, every single day. Like every single day. This is probably why I wasn't a part of this case, because who could do this every single day? Who is doing this every single day? Put that in the comment section. Let me know who is out there in these YouTube streets being a law tuber every day for YSL. You're a trooper. We got to find out who the troopers are. Oh, let's see. Oh, emergencies. Hello. Yeah, so that emergency, that client I was telling you about, I gotta go. I'm gonna be back. I'll be right back. You're not even gonna let us be gone. I'm gonna do this right. I'll cut it here and then we'll be there. All right. I'll see you in just a minute. See, it's like I didn't go anywhere. All right, so a little business out the way. But gotta get back into some other business. So we're gonna hurry up and wrap this up a little bit. So let's see what else is next.
Okay, so this is looks like an Airbnb, and it looks like people are just.
So I hope we can go with the faster speed, just because I want to speed it up. For me, you probably can't. You'll be like, it's too fast. But just know that even for yourself, you can, lessen the speed if it's too fast for you. But I'll go back to 1.25.
All right. What else?
Your Honor, I'm reviewing all of the notes from representations made by counsels for each of the defendants. And based on my review of those notes, I don't believe that there are other matters that we need to address at this time that are properly addressed without the defendants here.
All right. And do you have an idea of when you can get me the list of the rulings so far?
Yes, Your Honor.
And I know that's a bear of a task, so. don't want to be unreasonable about it.
Okay, I mean.
1 second, because we have already begun that process.
Right.
And let me, if the court will permit me,
Yeah, go ahead. He has to confirm, so let's get a date. Okay, record a date, let's know. Tell us.
and Your Honor, I know that we can have that list before next Friday, or at least by next Friday.
That'll be great.
Okay.
Thank you. All right. With regard to the most immediate scheduling, the kind of getting through, hearing argument on, getting rulings on the things we all just talked about that are pending. Is everybody available and I guess I've already got y'all, unless Judge Glanville had excused you, I think I've got y'all, but is everybody available? And I'm not saying we're going to be here 8 to 5 every day, the week of the 29th, but is the week of the 29th, everybody's available to the extent we need all of those days?
State's there.
Okay. Anybody not? Okay, perfect.
Your Honor, I'm not going to be available. I'll be out of town.
Because I'm thinking that at least most of that week, that's what we're going to be doing, which
That's
means
okay.
I am not going to be going to the judges' summer conference, but that's okay. That's okay.
Gosh,
Okay.
we got the.
All right. With regard to kind of further in the future, just when we're going to be having trial, I think it's maybe been like 4.5 days a week or something. I don't know. I guess it doesn't matter what it has been. Here's what I'm thinking. I am thinking that when we are in trial, we start at 8:45 and go to about 6, at least until the time changes and it gets dark early. And I'll have to obviously make sure that all the jurors can do that. I don't know what their, pick up kids schedule is or anything like that. But I want to make the most of our time, like I said, while we're here. And how.
Yes, finally someone acknowledges that the jurors are real people. They have kids, they have jobs, they have schedules. You're right, Your Honor. Yep, they have doctor's appointments. Good golly, can you imagine if you had a procedure or anything scheduled with your doctor and you had to keep changing it because this trial just won't stop? Can't stop, won't stop.
So that's kind of going to be my plan going forward. And it may be that.
And it depends on the procedure. Let me be clear. Obviously, if you have a doctor's appointment that requires a procedure or something of issue, you would tell the judge. I'm just being like extra. But I am saying and highlight that it's so many days. For goodness sakes, rule on the mistrial so we can go on with life.
We want to go all 5 days. It may be that we want to, break at lunchtime on Fridays. And if we have other business to do, we stay for the afternoon. And we may not start August 5th with the jury. We may have so much left to do still that we give them another week. But once we do start back with the jury, I'm thinking 8:45 to 6. And when I say 8:45, I mean 8:45. I intend to take the bench at 8:45. I know that the parties, the defendants will be here because the sheriff's office will have them here. I want all the attorneys to be here as well. And if you have 5 attorneys on your side, as long as one of them's here, we're going forward. Okay. So I don't want to be waiting around until 9:30 to get started. 8:45.
So that 2 hours that it took for some other hearing to transpire prior to, we won't have any of those, Your Honor, you sure?
All right, so that's that. So a couple of things have been brought to my attention that some people might like changed now that have a fresh face. And y'all, some of these are really kind of insignificant, but I'm gonna go ahead while we've got some time and bring them up. Food in court.
Okay, so here's the thing. You're not supposed to eat in court. You're not supposed to eat in court. And there was like some YouTuber, one of them, I think one of them said Judge Glanville was eating in court. I don't know that he was or wasn't, because I thought I saw him using like throat lozenges and then he would start crunching the throat lozenges. So it was extra loud because just like she's shuffling her papers, the judge's mic is extremely sensitive. It's on, it's loud. Now, the defendant's mics, if they're on, they're not loud, or the defendants are not close enough to it. I don't know what the issue is, but I have issues hearing the defendant's attorneys every now and again. But between the prosecution and the judge, I hear that very well. And I hear the background noise. So when he was crunching on his throat lozenger, or maybe candy, I didn't take issue with that. But I think a YouTuber or someone on YouTube stated that he was actually eating. And I don't, a throat lozenger or something, to keep your throat viable so you can speak. And if you're going through sickness and illness and you need the vitamins off of it, I don't think that to be eating. Even if you do crunch, I don't think that's to be eating. But I would think that the court reporter who's listening in their ears and they're typing would say, oh my gosh, can you cut off your mic? Please at least cut off your mic because you're in her ears. But interesting. So this judge is like, she's got to say there's no eating in the court. There's eating in the courtroom, right? I have never eaten in the courtroom. I've walked out of the court eating off of the truck. You know, that's what, like, all the trucks, the little carts and the street carts that we have on the East Coast. I don't know if you guys still have them, but when I was growing up on the East Coast, we used to have the street carts with the chili cheese dogs or the hot dogs and, you know, the sauerkraut. That was just the bomb, right? So, or the chili cheese, what was it? Frito pack they used to make for us or whatever. Those carts in Cali are like taco trucks, right? like usually they're taco trucks or fruit slices and things like that. Oh, and burritos and stuff. So I would go out there, stuff a few tacos in and go in, right? So I have never eaten in a courtroom outside of like maybe a throat lozenge or a mint, but to say there will be no eating. What?
They can have water whenever they want to. The attorneys can have, you know, whatever drink they want to, as long as you're not klutzy like me and don't spill it all over everything. I guess if you do, that'll be your problem. If we are working through lunch and the jury's out and we're working.
Maybe the defendants are eating. Defendants typically are not, well, these are rappers, so they probably eat in the studio. But typically defendants are used to, you know, taking breaks for food. Legal people, we're used to not taking breaks for food. Like, you just power through it all. So, you know, you get a power drink and that's what you do to keep energy up. You don't necessarily eat a power bar. Typically you'll well, for me, I'm liquid forward. I have all my calories in liquid form. I have lots of calories, but they're in liquid form most of the day.
And y'all are here and the clients are here. That's okay. But snacking while trial's going on, we're not gonna be doing that, okay? So if we are working through lunch, if we are working late and it's dinner time, it will be okay to the attorneys or the defendants have food. Not while somebody's on the stand testifying, okay? We're not at a movie. We're not gonna be eating popcorn. All right. Hopefully that'll be all I have to say about that.
Okay.
Apparently, one of the first things that I don't know how many different deputies told me was the clothing for the clients has gotten a little out of hand in terms of how much they all have now. So, you know, I don't know, but y'all need to maybe get together and let's exchange most of that. And sure.
Wait a minute. Not the deputies complaining about the stylist. The stylist is like, look, I need to make my money, okay? Look, here are the clothes. Here is the extension of items. Here are the clothes. Here are the extension of items. By all means, pick an outfit. Monday, Tuesday, Wednesday, Thursday, Friday. Hey, pick an outfit. You know why? Because remember when Little Woody was like, well, if you read the ex parte, word for word. If you read the transcript with me, you know. If you don't, you can go find out. But there's a point where Little Woody is like, no, don't change my clothes. And then there was a point where the deputies were like, well, we have a large, but he's smaller than that. And so we really don't have his size. And the guy's like, and Mr. Copeland's like, no, don't change my clothes. And he does it for a reason. He's like, show them what you did to me. Show them. Leave me as I am. And so in that instance, he was put in contempt for what he believes asserting his Fifth Amendment, because he pled the Fifth. And so he was jailed. So since he was jailed, he's in jail uniform and in shackles now. So there's a switch from when he first came in regular clothes to now coming into court in jail clothes. And he wanted to make sure that the jurors saw it on display what you did to him. And that's how he felt about it. He felt set up. He felt, you know, he had a right to invoke the Fifth Amendment to be a citizen of the United States and invoke his Fifth Amendment right. And you put him in an immunity deal, and now you got him in handcuffs because he broke the Fifth, and you know, so all this stuff. He wanted the jurors to see the visual. Well, I just want you to take note of this. All of these defendants are typically in their jailhouse uniforms when they're, you know, obviously at the jail, jail, because that's where they are. No one has gotten out. There's no bond. So, but when you come to court, you are supposed to, or at least allowed to, have clothing that represents you as a citizen. So you're not supposed to be seen in an orange jumpsuit per se, before the jurors. So you're allowed to get regular street clothes and have those clothing available to you. So the staff, sometimes the courthouse will have some clothes on hand, maybe not the cutest of things, but something that makes you look like a person versus a criminal. And that is the way to avoid prejudicial, blah, y'all gonna love this one, prejudicial viewpoint to the jury, so that there's no prejudice against the actual defendant. And that prejudice would be if you're in something that looks like you're a criminal, then you being accused of being a criminal, then you must be a criminal. So consequently, that's the clothing that's the reason why they don't make you wear jail clothing anymore in front of the jury. They're supposed to allow you regular street clothes. Well, some of these defendants are affluent enough to have clothes. And it sounds like they got stylists, and they're not needing you to provide them with that raggedy oversized overcoat because they have clothes. And they're pretty much well attired for the courthouse. I am surprised that it's a closet. So she's like, there's a closet specifically for these guys and it's overflowing. You got too many clothes. I would think the stylist would come once every 2 weeks just to, refresh the closet. But yeah, they brought the wardrobe in. This is funny. Good grief. What a case. We're doing all things in this case. We've got ex parte hearings, sworn witnesses. We have rap lyrics coming in as evidence, and we've got wardrobe issues, like wardrobe malfunctions. If you know, take it back to the days of the early 2000s, okay? Just Janet Jackson, girl, this one's for you.
They can have new outfits for court, but it sounds like they're like full wardrobes full of clothing for some of these defendants, and that's just.
They gotta have options, Your Honor. They don't like every sweater that's there. They may not be feeling that color that day. I love it. I'm here for it.
A lot for the deputies to have to keep up with.
Be blue one day, be red the other. And then you know what? That too could be like against this gang theory, right? I gotta wear every single color, or I can't wear no colors at all. Like, which one are we doing? Like, we gotta have strategy today, because Copeland's coming back. He don't say we're a gang, so maybe we should just wear all white and be like angels.
So how about if y'all check in and maybe through Miss Rosser, y'all all know Miss Rosser, I think. She's not even here today. Yeah, she is over there. Miss Rosser, my fabulous litigation manager. And let's make sure that it gets whittled down to a manageable amount of clothing, like there are only going to be 5 days in each week. So even if they had a different outfit every day, that would only be 5 outfits, okay? We shouldn't have 20 different outfits for anybody. So y'all need to clear out, apparently, the closet. So.
It's been 100 days. It's 100 days. So, is it the same wardrobe for the last 100 days that they just are shuffling around and just rewearing, reusing? Or you actually gonna have 20 outfits for any given day? Come on.
So now I've done that for the deputies. They'll be more happy. Next topic.
Deputies are being haters.
Minimizing disruptions in court. I don't exactly know what that means yet, but let's try to conduct court in a way that minimizes disruptions. And
she really has not seen this case. Like, if you don't know what that means, there's so many other things that means too, because they had the instance where there was security disruption because they felt like there were people that were following Copeland around that should not have been, deputies, officials, and then unidentifiable, more armed-like individuals like FBI or undercover personnel. And then there was this one gentleman that was looking outside the window and piercing at him while he was on the stand the whole time and looking him down. And no one seems, the judge recognized that happened as it happened, but they started talking about it after the fact. And no one identified the gentleman. No one, shooed the gentleman away. No one told him he was improper by standing in such way. So Copeland was on stand and he was getting stared down by somebody. So those type of disruptions, Your Honor, those and the others, when they go back and forth and holler, and Judge Glanville would holler. So hopefully you don't holler, but it was all things were there. Every disruption under the sun was there. So she really does not know this case. There are people, I am absolutely at awe that there are people in Georgia that don't know about this case. Good golly, Miss Molly. Good job. Good job, Honorable Whitaker.
This month only, we're looking for 200 homeowners.
Oh, good job.
Interested in
We'll just leave it at that for now. There was an issue about apparently, and I'm not even sure if I understand exactly what has gone on with this, but the defendants listening through earpods to things on laptops while court is going on. And I'm not sure I understand why.
saw that, I saw that, I saw that. They was bobbing too. It was like, I did. I saw that when Mr. Williams, he had his dreads down, or braids, I guess, whatever type of style it is, and he put the ear pods in, but they weren't the pods, they were with the strings, and he was like dancing. I said, "Oh my gosh, you're not supposed to be listening to music in court." But I look.
Why that's happening, and that raises some security issues with our security staff, with the sheriff's office. So can somebody kind of explain to me what that's about and why that's necessary? And if nobody wants to, then we'll just do away with it.
No, come on, Phil. Where's Phil? Brian. He go to sleep. Where's Al?
All right. Well, we won't be bored from here on out. So then, if that's the only reason for it,
Who said boredom? Who came up with
all right.
boredom?
Well, we won't.
Who was that?
I think it was originally combat boredom.
All right. Well, we won't be bored from here on out. So then, if
I don't even know that guy. No, that was a stupid argument. No, not bored. Okay, listen. Yes, court is boring. That's why I'm here. That's why I'm here. I'm laughing. I'm hyping it up. But it's boring. I get it. But no, that's not your argument in this moment. Where's Brian and Adam? This was perfect. This is a moment of glory. You missed it. This is the perfect time to say, Your Honor, respectfully, the state has been allowed to go against First Amendment rights and present rap lyrics in parse to the jury as evidence. There have been times that my client or clients, defendants, have had to review these old songs to let me know, because I'm old and I don't know what they said in there. They mumble rap. I don't know mumble rap. So they had to let me know what the words were that were missing so I can make the proper objections. And we have done this prep, outside of the court. But when the, prosecution decides to insert, because remember that time with the chicken and the other one, insert 3 different new audios, it sometimes requires us to listen collectively to what the evidence is so we can, in fact, know if this is the one we need to object to, because things are moving and we don't want to slow down the progress of the court. So we need to have the availability to review the evidence in real time, just as if the evidence was, I don't know, on a sheet of paper. I want to be able to pass it to my client and say, do you know what this is? Since we have audible evidence, sometimes we're having to double check that evidence in real time, Your Honor. So we have had the ability to do so, and I kind of think we should maintain that decorum. Like, make the prosecution get up and work some. And not to mention, show and remind this judge that we are trampling over First Amendment rights of artistry through, admission of evidence of rap songs, not poems, even poems, but still, like, of lyrics. I guess rap songs are poems. I take that back. But they were putting in artistry as a form of evidence. So we're listening to them, Your Honor. When they change up some evidence, we're listening. They got a pod, I got a pod. Like, we got to listen.
If that's the only reason for it, I want to be moving forward efficiently and expeditiously.
Not boredom. That's disrespectful to the court. The court knows they're bored. They don't want to be reminded that they're boring. But no, actually, the thing about that is the court is bored, and it's really hard for defendants to stay into court, especially creative thinking individuals. When you're a creator and you want to create, you want to do. So some of the better things to do is to give them pen and paper, give them maybe colors or something. And that we were able to see Johnny Depp do in the Depp v. Heard trial, where he, colored, and people thought, oh, that's so funny. No, it's truly to channel boredom, but you're dealing with other types of artists who are, audible artists. And so maybe they need the beat. But I would express to them, you can't have them onto the courts, or at very least, no bopping of the head. And then truthfully, write the poem, make it a poem, make it a book, write something else, just so that they can not be bored, because it is boring. But you don't tell the courts you're bored. You don't tell the courts you're bored. And the court's going to obviously take issue with it, because to them, to the judge, their responsibility is to make sure that all the defendants all of the evidence has been presented and the defendants have had the chance to object. A part of the defendants having the chance to object is that the individual defendant taps their attorney and is like, hey, yo, object to that. Don't let that get in. That's not. You are participating, even though you're not the one speaking because you're being represented by counsel. You have to be able to participate. So they're expecting you to be there And they're obviously expecting you to pay attention so that anything that is improper, you can in fact say to your attorney to, make an objection to this because I don't think that's right, or at least have some type of coverage. So anyway, so that's the point. That overall, the defendants must pay attention because it's a part of the fact that they have the right to confronting the witness. You are lessening your ability to confront the witness when you don't pay attention to what the witness is saying. And the court has now taken note of it. So since the court notices that you're not paying attention, they have to make you pay attention so that your rights are not being trampled over, even though you may be waiving the right. The court's like, no, you're not going to appeal me.
So let's just plan to not have that happen anymore. And if there arises some new reason for it, then we can address it again anew. Okay?
Sure.
Yes, sir.
Before we get into that, Mr. Huey, there are times where the defendant might need to listen to evidence, interviews, things of that nature, and I've made that available for my clients to listen to some of the interviews from witnesses, testimony, prior interviews, things of that nature. For evidentiary purposes, that would be a request for my client to be able to have that access where necessary.
So why is that happening in court? That seems like something that should happen after hours between the two of you.
Sure, I understand that. Just maximizing the time that I have with my clients since I don't have availability with them outside of court every day. So he's here, we're here. So a lot of times I'll give them an opportunity to review evidence and things of that nature.
All right.
The only reason I would ask.
I'm going to ask that you try to get that done outside of courtroom time. And if there's some sort of an emergency, unexpected reason why something can't have been reviewed before, then you can bring that to my attention. But okay. All right. I would like to find out from kind of everybody.
He tried my theory.
Vernon Central High School, how may I help you?
He tried my theory. I was trying to get it in for you, but where's Brian? What happened? I guess he knew it wasn't gonna fly. He's like, I know this judge. She's not having it. Everyone's like, they have such a great rapport. I bet you everybody's gonna be like, see, this is why she should recuse herself. Her rapport with Mr. Steele is just so nice and welcoming compared to Glanville, who was making sure that he didn't get away with anything. No, just kidding. But yeah, Adams and Steele didn't come in with my argument. I thought I had a good one. I think that was a good argument. You're supposed to at least make it. If it gets shot down, so what? Put the judge on notice. Look, we got First Amendment issues. We're gonna appeal this.
How many witnesses there are to go and what you expect those witnesses to say. And one reason I say that is because Judge Glanville had entered an order, which I may not have brought downstairs with me, but y'all, when I describe it, will probably be familiar with it, that essentially said everybody, not really, but several parties have asked for mistrials, I think, because things are moving so slowly. And he entered an order that seemed to say, it appears that the state has 200 and something witnesses. We're on 50 something now. Everybody's causing disruptions, or not causing, but there have been a lot of disruptions because a witness is on the stand and all of a sudden one party or the other comes up with some video that nobody's ever seen before. And that's the reason for all of this disruption. But at the same time, maybe some of this can be whittled down. And that is a wild paraphrase of that order, but I think y'all know what I'm talking about. What I want to know is, where are we really? I mean, I know, witness lists look one way before the trial, and who you end up calling oftentimes ends up being something different. I know this is a multi-count indictment. I know that there are a lot of defendants involved in several different incidents. And I don't expect this right now, but I would like from everybody, to the extent the defense knows whether they're going to present a case or not, a realistic list of witnesses, maybe like what counts they go to and what you expect those witnesses to say generally, broadly. Because this case has been going on for a really long time. And there is a rule that lets me exclude cumulative evidence. And I might end up using that.
I like her. She's like, we're not wasting no much time. I don't have time for this. Stop. I'm liking her. She's whipping it. And she's doing a good job at being personable enough. There's no flares, but there's no opportunity for flares. It's just status conference. So basically the judge is just telling you how it's going to go. And then you let them know whatever questions you may have or what you're looking to accomplish on your side. But you know, it's just a status conference. We're not yet in trial. Like it's a part of trial, but we're not yet in the heat of it. We're not in the argument stages of it. So we really don't know temperament yet. But so far this is good. I'm liking this. Very structured courtroom. So in her presentation, and I'm sure Judge Glamble probably gave a great structured set of order too, standing order as to how the court will go. But you know, things happen. But 200 and some odd witnesses, like prosecution, girls, guys, gents, people, all come, please, 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 please. Do y'all have a case? Do you have a presentable, provable court case? Not in the streets. I understand perception and the possibilities of truth may be there, but do you have a provable court case? And then sometimes, like she said, the witness list can be like 3,000. No, it's not gonna be that, but it'll be like 100 million witnesses just to be like, look, I have all the people that know all the things and they're going to testify against you. You should just plea out. It's like a form of like, if I have to pull up, I have to, I will. Doesn't necessarily mean that they will, but good grief. 200.
So how about y'all give me a heads up?
I mean, that's like, there's six defendants, 200. I was gonna say, even if you had like 5 per defendant, right? Or 20, let's say you had 20 per defendant, that's 120 witnesses. And there is a cumulative rule, meaning that, you know, if the evidence that this witness is testifying to is the same as the next witness is testifying, it's cumulative. We don't need to keep hearing we don't need to keep hearing the same set of evidence over and over again with different witnesses, unless it brings in new evidence and maybe they're confirming a foundation. But even that can be extensive. I mean, Lolly and Karen, the Massachusetts Karen Reed trial was poking that bear, because it was like, how much more of the snow? How much more? Snow is snow is snow. It was snowing. We see it. We believe you. We believe you. You have proven snow. You have not proven murder, but you have proven snow.
All of that. Okay. And if that is something that y'all could have to me by next Friday for everybody, that would be great. Let's see what's next on my list. With regard to kind of just general scheduling, other than the week of the 29th, and then I was told, I think.
So this is kind of how it goes.
Monday through Thursday of August 19th through 22nd.
Okay, we have.
Is anybody aware of time that has already been given to the jury as you're out of?
No. So, I can't do too many things at once. So sorry about that one. But it does give a great reminder that this is the time for the commercial. So like, share, and subscribe. Okay, thank you. Put a comment in. How you
Does
feeling?
any attorney right now know of a date that nobody from your team can be here?
How you like
And I would
Judge
expect
Paige
that
so
to be
far?
the case because y'all are in trial, but
It's satisfying.
no, I mean, anybody getting married?
You having a baby? Like, can we get into that? Like, yes, Judge, let's find out. No, she's really just going after, do you have anything really important, life things going on, life be life. And so, you know, you have life things happening and so forth that would require us to take time off, because she wants to pack the calendar, because she wants this done. And every judge in Georgia probably wants this done. But she's extending the days. She's trying to put in the extra time. One, she's gonna have extra time just to catch up for what has happened, but also to, in fact, get prepared for what's getting ready to happen, for what is, you know, set out to happen relative to the evidence and the witnesses. But she wants to be done. Okay, I want to be done too, but I don't know. We're gonna keep it going. This is the basis of a status conference. They're boring. This is the boring part, but the defendants are not here. I don't know if they get to listen to music in jail, but they're probably, you know, bopping there. Maybe they're making their music. Listen, support them. Support the music. That is a very, I have no idea what songs are. It's not my thing, but if it's your thing, support the music. Because these attorneys need to get paid. Attorneys are like, I need to make money. And the client needs to be able to pay the bill. So, and the client needs to be able to put, pay for the children and the wives and whoever else, the dependents, whoever they may be. So support the music. That in and of itself is legal.
So I hesitate to even say the next thing I'm going to say, but I'm going to say it anyway. The little bit I have seen about this case, it definitely has appeared that there have been times that tempers have flared a whole lot and that people have been maybe less than professional. And I hope that this kind of breather has given everybody a breather, and everybody has.
You don't say, Your Honor. You don't say. Just times.
It's been absolutely wonderful here today, but I would like for us to maintain a degree of decorum and dignity and professionalism. That is what is really expected of all of us as members of the bar. I don't want to have to say anything beyond that, okay? But if it gets to a point where I think that is not being carried out appropriately, we're going to all have to talk, okay? All right.
So actually, I love that she said a thing, but she did say too much. Or to me, I think I would have liked her to have been a little less critiquey. So to say that I've watched whatever I've watched, I've seen whatever I've seen, and that for which I have seen has shown poor decorum. Instead of that critique, I'd rather her say, I want everyone to be made aware and to be reminded that in this court, like any other court, the proper decorum is required. This court will not accept anything other than the proper decorum. And at any instance that this court has to address and or reprimand for poor decorum, you know, the repercussions may be heavy. Please respect the court. We are members of the bar. Let's order ourselves according to the professionalism for which we are called to do. That, or to say, I respect you, and I know that you have the ability to operate efficiently and appropriately in this court, so that is the requirement. I will not lower the standard at any point in time. The standard has remained at its level of high responsibility to the court to be respectful, professional, and of the decorum appropriate for court. So whatever way, but I think what I've seen has not been so great, and so therefore that it's like you're traveling to a different lane, and she was staying pretty midstream so far, so stay midstream. Do not give any teeth to you have a bias. You have a preconceived notion. You have, negative influence relative to, performance of one attorney or another. Stay midstream. Stay straight down the arrow. Keep it straight. Keep it straight. No commentary. That's my job. I'm the secretary. I'm the lady in the box. I make comments, not you. Okay, let me be the one that says the ridiculous things. You stay midstream so that we can have this case wrapped up. I mean, they're probably going to appeal for some other things, but we're hoping. We're hoping we don't get a mistrial or whatever. We get a non-guilty. If we get a not-guilty, we don't have any double jeopardy. But if we get a guilty, we don't have to appeal because you somehow did something nefarious or you had a bias. So they don't know if you don't tell them.
All right, what else do y'all think that I need to be thinking about, or do we need to be talking about, or at least
clap it up for the South, y'all. I'm loving it. Yes, Southerners, y'all. That's I love it, and that comes out in my speech every now and again. So it's like, oh, you're so country. I'm like, yep, I love it. Don't you love it? Country is so good.
do y'all think that I need to be thinking about, or do we need to be talking about, or at least raising to talk about later? In anything from the state?
Your Honor, I believe that the court has sufficiently addressed everything that we had anticipated we needed to address with the court.
Good, because I want to go.
Ms. Weinstein?
Y'all good? Oh, no.
Okay. Mr. Sharp, anything?
Sharp, that's the thing. Hey, Mr. Sharp.
There have been, this case, as you know, is enormous, and the discovery is enormous. There are certain.
Okay, so this is looks like an Airbnb, and it looks like people are just walking through the kitchen.
Can't. I just can't. And someone said, buy the YouTube free commercial version, I guess. I might have to do that. Is that what's going to solve this problem? Because this is like, I don't have another commercial for you. I'm the commentator. Like, share, and subscribe. This is very simple. All this same commercial over and over again, boredom. We don't need to listen to some YSL music.
Judge Glambo, we have some general rulings about some matters, but not particulars.
Okay.
I'm trying to give a heads up. This is an example, but I don't think it's the situation. I have filed a motion regarding those wiretap incidents.
Okay.
And and the judge overruled my objections and stated that the wiretap was legal. He made that finding. However, there are other issues about the wiretap and the particular things said in the wiretap. Some of those pieces of communication may be admissible, may not on an individual basis. Certain things like that, I'm just giving the court a heads up, have not been parsed through to the particulars.
Okay.
And we've discussed like
That's
need
the
to do
motion
those
eliminate?
things, and some of those things we kind of kick the can down the road a little bit, so they're still outstanding.
Okay.
I just wanted to bring it to
All
you.
right.
I could have sworn she said like 20 minutes ago that all motions eliminated will be addressed later. But maybe
So maybe when everybody is putting their lists of witnesses and what they're generally going to be talking
got
about
more
together, they could also, I don't know what happened.
it always takes the nerd in the room to stand up. And it wasn't Brian. It was you, Sharp. You stood up and gave people more homework. We don't need more homework. There's so much homework to do already.
Michael, they could also include if there's any kind of either voluminous evidence, video evidence, audio evidence that we need to be considering admissibility of before the witness testifies. If y'all can maybe list out for everybody what that is, because yes, I absolutely want those things to have
My paralegals in the YSL case, you deserve a raise. Okay? Know your worth. Oh my God. Oh my God.
been determined.
You know what? If the attorney came back and was like, hey, Mrs. Armstrong, I'm gonna need you to do yada 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 yada. If they came back with this, I would just look at them and go, say what, who the F, who, how? You must be okay. So the whole office is getting ready to do this, right? We're gonna get all of the paralegals together, right? What? You bringing in new staff? What you doing? Sound like you got some hands on deck for me because there's just so much homework. Sharp. Thanks.
Before, witness Smith gets on the stand and we have 18 hours of some kind of video statement that nobody's thought about yet. I'd like to say I'm sure that all of the evidence has been exchanged by now. Would I be correct in saying that?
There's reports that we're still missing.
Your Honor, I think detectives are still trying to find witnesses. No, I'm just kidding. But there's 28 defendants. Like, you know what happens when you go to one witness? They have like 5 things to tell you. And 3 of those things you've already heard, but 2 are brand new. And now you gotta go chase rabbit holes for those other 2. And then you talk to another witness. And man, I hope it's not a rabbit hole. I hope you have a case. But yeah.
State has said that they don't have those reports. Officers have testified that they wrote the reports.
Okay.
And we're still
We
missing.
got outstanding reports.
That's been a recurring theme.
All right.
Okay.
If everybody wants to detail anything that they think is missing, and I'll hear from the state on whether it is.
You see that? I love it. That's how I love it. I love it. Yes, you're okay. Wait, I gotta get my gavel. Hold on. I just gotta get it. It's just hold on. Okay, so Your Honor was like, I want you to take notes. If you got a problem, write it up, and then we'll let the state, address it at that time. Go ahead and sit down, Ms. Love. Thank you. Like, Your Honor was on it. She's like, no, we're not getting ready to go back and forth, back and forth, and back and forth. You write it, you respond to it, I'll read it. Okay.
Either missing, about to show up, or does not exist, that'll be something we can take up substantively, just so we start out all on the same page.
Yeah.
If you're happy.
Oh, well, God bless her heart, but still. How can I be happy? 11 alive. I'm not happy. I'm not. How can I be happy that every 2 minutes you have a commercial? There's no happiness.
Something maybe y'all can do next week, and we'll take
Charge more per commercial so you can lessen the spin, okay?
up the week after that as well. Okay, because yeah, if we need like 5 days of motions in limine, we need to do that. Okay.
Judge, I just want to make clear that the state has complied with the discovery obligations that we have turned over.
Oh, she just got to answer. Ms. Love. The judge has ruled, Ms. Love. The judge has ruled. She done told you. She said to them, if they got an issue, they're going to write it up, and then you respond. You don't have to respond to everything. This was not your time to stand up.
Discovery that exists in this case, and as the court is aware, discovery is that which we have.
If the issue is mute, then stay mute. If it's not an issue, don't. And the reason why I say this is because ADA Love had a different rapport with Judge Glanville, Chief Judge Glanville. And that was very apparent. And it may have developed within the case because I don't know how they started off. They may have not started off on such a foot, but towards the latter of what we saw, they seem to have a very good rapport. The jumping up and down and the exchange and the repeating what he said and turning it into her argument and him throwing her a bone. It was a constant viewing. She has to build a rapport with this particular judge. And the judge just ruled. She just gave an order. Listen, you defendants got issues, write that up. Then we'll let the prosecution respond. If the prosecution thinks that you're wrong, then the prosecution respond. Right now, we're not gonna take it up an issue. Like, it's whatever. If you got an issue, write it. That means there's nothing needed to be heard from the prosecution because they have not written up any allegation yet. But the needing to be heard and the needing to put the argument on, that can bite her later. Because I believe Judge Whitaker likes structure. And she don't like you popping up and every moment you got a response when she's already made a ruling that says the response will be in writing. The motion will be in writing. Everything in writing.
So we can turn that over. And we've actually gotten and requested, we've sought from outside our office any other materials that existed in the universe. We will do as the court has instructed and provide to the court a list of matters we believe have been unaddressed still as they pertain to our requests for reciprocal discovery.
Okay. And Mr. Shard, I know you've been in my courtroom before, and typically I have.
So you know what that was? That was, they haven't responded to us, Your Honor. That was a tattletale. That was a standing up to tattletale. Like, how dare you call us out when you haven't done this? That could very well be the case. The judge already said put it in writing. So put yours in writing too.
One side or the other, list out specifically what they think is missing, and we inquire about it and try to get to the bottom of it. So that's what we will do. Y'all make up the list, and then we will do that. We'll actually go through it in detail so that everybody knows what's going on and we all are on the same page. All right. And y'all, for any evidence that there hasn't been a ruling on yet that I'm going to need to consider the admissibility of, I obviously am going to need a copy of that. So if I've got 5 hours of some audio to listen to, I don't want to listen to that in court. I want to listen to that beforehand so that I know what we're talking about before we get to court to hash it out. So,
Judge Whitaker, do you know mumble rap? Are you able? Like me, I'm like, listen, I'm a Pac and Biggie fan. Like, I need you to articulate the words so that I can understand. I don't know. And I'm hoping these words are articulated by Young Thug and crew, YSL, the YSL Entertainment folks. I don't know, but most of today's rap, I'm like, what is that?
Get me all of that as well, and that'll be more homework for me to do.
Okay, we all got homework, Deanna. Yes, it's a lot of homework.
Okay. All right, then, so let's go through anything, either Mr. Williams or Ms. Sabasti for your client. Okay, Mr. Harvey, Mr. Steele.
Okay, we done?
No,
Okay. All right. Okay, the next thing I want to raise, and I have no idea what has happened before now, but I would like to encourage everybody, while we are kind of in this pause, to...
You have a commercial? Gosh. I am, because I am. I'm not I am, but I am. God is I am that I am, but I am going absolutely bananas over these, like.
Whether there are any plea negotiations that might.
Wait, what are we doing?
To talk to each other about whether there are any plea negotiations that might be fruitful, whether there is any room for movement by anybody on anything, any plea. I mean, I'm willing to entertain.
God bless her heart. She says, we are embarrassed enough. Can you plead out, please? She can't say that. I can say it that way because I'm the commentator. I'm the lady in the box, right? I can make these noises. She cannot. I can do these comments. But she's like, for real, like, just, agree. Agree to disagree. Who cares if you agree? Just kind of agree.
Any kind of plea.
Like time served, half time. I don't know.
At any time. It can be a joint recommendation. It will be non-negotiated since we're in the middle of a trial. But it can certainly be a joint recommendation, or it can be.
Great job.
State wants this, defense wants that. Or it can be, we all want to keep going with this trial. I am here to give everybody a fair trial and everybody a fair shake, follow the law. But I invite during this pause, if y'all want to think about that and talk about that, now would be a good time to do that. Okay. All right. So I think that.
I don't think it's the state who's not willing to make negotiations. I'm pretty sure the state is like, yeah, let's negotiate. You go ahead and plead guilty. And we'll take whatever time. I think it's the defendants are like, no, what case do you have? You haven't proven anything. Matter of fact, I'm about to get this thing thrown out altogether.
Y'all have a lot to do and I have a lot to do, and we will plan to get all of our filings and all of our responses in before the end of next week at the dates that I had provided. And why don't we plan to maybe not Monday, but Tuesday, the 30th. I'll convene here at 8:45 and just start tackling everything that got filed, okay? And we'll plan to go pretty much all day until we finish, every day that week. And
see, you know I love you because I would speed this up.
By the end of the week, I'll know whether we are at a spot to bring a jury in or whether we need another week. All right, anything else from anybody? Yes.
The court instructed that we provide the court with evidence for which there may be admissibility issues.
Yes.
I wanted to ask for the court's clarification if that meant whether there have been prior motions to suppress filed, or if the court is instructing that, notwithstanding the absence of a motion to suppress on a particular piece of evidence, that we are now going to be entertaining motions to suppress. For instance, if there's a recording that we have turned over, will the court be entertaining motions to?
So I don't really know what the expectation has been. I mean, if this had been my trial from the get-go, we'd have litigated all the motions to suppress by now. Motions to suppress shouldn't really be getting filed mid-trial. That being said, I would rather, if somebody is going to stand up and say this is 100% unconstitutional for X, Y, and Z reasons, I shouldn't be letting in something that's unconstitutional for X, Y, and Z reasons. So I'd like to know it, but I mean, I want it to be a legitimate, valid concern, evidentially, constitutionally. I don't want it to be, here's my chance to challenge everything under the sun.
See what I'm saying? The microphone somewhere, and I think it's hers, is very sensitive. So that swatting that she's doing, because she talks with her hands like I do, to be doing this. Just kidding. She getting crump. Just kidding. That's giving us feedback.
So there are chunks of evidence that everybody has just basically not gotten to yet, and y'all sort of said, all right, we'll get to that when we get to this witness. And if y'all been operating on a kind of rolling, all right, when we get to this witness, we'll deal with that evidence, then if that's what the expectation has been, then I wouldn't expect y'all to have all filed all of your challenges. I don't know what's been going on.
Your Honor, that has not been the case. No, but because of the way that the court indicated that the court wanted parties to provide evidence regarding admissibility issues, I just wanted to make certain that I understood what the court was instructing. There have been evidentiary issues that I believe the parties disagree on. The state disagrees with counsel for defendants' interpretation of what is right and what is valid for contesting at a particular moment. I don't doubt it will continue to arise. I was asking as it pertains to what the court instructed just a second ago regarding evidence. I didn't know whether the court was doing something different than what I did.
So I don't intend to revisit rulings on evidence that's already.
How to open your car door while submerged underwater. A fatal construction flaw in all recent auto.
Come in. But for evidence that's already come in.
Yeah. She's not gonna
but for evidence that we know is out there and was going to be introduced a month from now with, witness Jones, if y'all have been doing that on a rolling basis and y'all know that there are going to be evidentiary issues with it, things that I would have considered motions in limine, then I want us to all go ahead and voice that now and sort it out so that we know.
She's so funny. It's kind of cute. She thinks that there's like some consistent presentation of the case to where it's like, well, if you have consistently used a witness to input each evidence, but prior to the witness coming on the stand, you guys deal with motion and limines at that time to determine what comes in, what does not, then we'll keep with that. Because typically suppression and MLIs are done prior to the trial even starting. So it's a collective motion. It's not, or it's all of the evidence at once, and you go through and say what is and what is not admissible, and you don't have to deal with it on an ongoing basis through the trial process. And ADA Love is like, no, we're not doing it that way. We're not doing it on a rolling basis. I'm just asking relative to what you're speaking about. I don't even know what she's talking about, to be honest, whatever she's talking about. But judge is like, well, I just want to be consistent with whatever your consistent developments have been. And I just want to say, judges, it's been 100 days. There's no only thing consistent is that this trial is still going on. There's no consistency in rulings. There's no consistency in evidence. So
When the witness shows up, what can be talked about and what can't be.
that's a
And
consistent
I don't know if that gave you clarification. Okay. All right, Ms. Abbasi.
Yes, Your Honor, if I may, I have to disagree with this thought that it's been going along, that we've already had motion, but it is not admissible. Just to propound on what your Honor was mentioning and what the task of defense faces, we have a list of 8,000 jail calls. We are having listened to 8,000 jail calls, and I think probably a majority of them are not relevant. Everyone would.
The evidentiary. This is why I say give the shout out to the paralegals, the secretaries, the assistants, the copiers, the tech team, can you imagine the war room on this case? Oh my gosh, all the war rooms that have to be locked down and all the security that has to be developed for the war rooms now because it's such a high profile case. Shout out to y'all. Because this woman just said, she said 5,000, thousands, 8,000, thousands of phone recordings. And it's because it's 28 of them. I don't know if the other recordings are a part of that, but there's 28 defendants, lots of people in jail, or whatever, 18 defendants. I don't know, who cares? There's a lot of them. Lots of people in jail for 2 years, and you're still, of course they're monitoring. They're monitoring the calls, and consequently, someone has to get through all the calls to make sure that they're not admitting to any crimes. Or, oh my Lord.
Agree that they're not relevant. The state's not actually.
And you know how we're sitting here listening to this? This is life. This is life of a paralegal. I once had to go through someone's Facebook account. The person was so self-absorbed. The Facebook of it all was they were self-absorbed. I guess social media is that presentation, but it was just like and the person was always naked because they were a model, so they only wore bikinis. And I had to just go through the account. And I had to find, and I couldn't just go through the pictures. Okay, because that's one thing. I had to go through all the comments with millions of friends and comments, and it got to a point where it just was start from where you can, go from where you can, and just go backwards. Start from here and go backwards. Or no, I think it was start from this time frame to this time because we had a time frame in mind. So we had a time frame. But it was grueling. It was boring. But you couldn't skip a picture, you couldn't skip a post. Now you have to do the drop down arrow and all of them show up, and then you got to go back, click this, because what they'll do is relevant posts. You got to click all posts now. When I was doing it, it just would, if you did the drop down arrow, all of them would show up. No, you got to make sure it's on all to show up. Otherwise, it's only relevant posts. Like, it's so annoying. But back in the day, when I had to do it, when Facebook first came out, it was immensely annoying. And I hated it. And I loved it. But that's the point. We're sitting here, we're going through every painstaking detail of this most boring moment because it's just status conference. Because we're vested. We want to see what's up. What are we doing? How are we doing? That is the paralegal side of us. That's the legalese. That's the nosiness of us. We got to be legal people have to be nosy because otherwise you'll never find anything out. Like that, no one's just going to tell you. You got to be able to be nosy too. So in our nosiness, we have a place. We are welcomed here. Nosy people are welcome. You're welcome here. But I don't want to listen to the jailhouse calls. This is why I probably did do criminal law. I'm only on the civil defense side because I couldn't be. I don't want to listen to you talk to your baby mama, or your wife, or the mother of your child, or children, or your mother, or your bestie, or your not so bestie, your cousin. I don't want to hear it. I especially don't want to hear like I miss you so much. I love you so much. Oh, we did this. Oh, I watched the show. It's called this, and they did that, and because you were trying to normalize, and that's what you're supposed to do, because that's your man and that's your girl or whoever. So love them. Have those moments. Have those calls. I just don't want to listen to them. So shout out to the paralegals that got to do this, because we got to listen to calls. Thousands.
Okay. However, defense or burden, you don't raise the objection, it's been waived, and then it comes in at trial.
Okay, so that's why the witness list with what this is relevant to and what evidence is going to be used is going to be, I hope, very helpful in giving us all a better kind of groundwork.
Yes, Your Honor, that is precisely what I'm asking.
Okay.
20,000 pages of Instagram, based on DVDs.
Okay.
20,000 pages of Instagram. Yep. Yep. Yeah. I had mine was Facebook. I think another paralegal had Instagram. I don't know if TikTok was a thing, but we had at least those two, and it was like we both were like, like, oh.
And
Yes, Mr. Adams.
good afternoon. Again, Judge Keith Adams with Mr. Steele for Mr. Williams. Just to, I think the court wanted to know if there are things that Judge Glanville had been doing in regards to that particular issue. And I did want to just attend to what Mr. was saying. For example, the jail call, the interviews, that generally speaking, there have been errors on the admissibility of those statements.
Okay.
But the court has oftentimes said, I agree that, for example, this statement may be admissible, but there may be some things in the statement that's objectionable.
Sure.
We'll deal with that.
Okay.
At that time. The court has routinely been doing that. So not necessarily kicking the can down the road, but addressing issues as they come up. And
Okay.
has urged both sides in advance of that issue coming up. If we can get together and iron some things out, let's do it. We've been working to do that. But there have been routinely times where we said we just disagree. We've had to take those items up. And I think what you would like, what Judge Landell has asked, is that let's let you know about it as far in advance as we can. That way you can set aside some time to deal with it.
People ask me all the time, Chris, if you could only take one supplement for the
Absolutely. I mean, that is, I want to be respectful and cognizant of the jury's time. I also want y'all to all know what to expect to the extent you can, and litigate everything that we can litigate beforehand, if it's going to be necessary. Now, if there's some totally irrelevant Instagram post and the state knows they're not going to use it, but they listed it a million years ago, their updated list that they're going to share with everybody should not include the Instagram post that they know they're not going to use. So. All right, so I will expect whatever filings y'all, I will anxiously anticipate all of them. Make sure whenever you file anything that you contemporaneously email a copy of it to Ms. Rosser, because the court and chambers do not automatically get what y'all file. I have no idea what you filed unless you actually let us know. So make sure that when you file it, you send a copy to Ms. Rosser so that we know about it. Okay. All right, so I'll plan to see everybody bright and early at 8:45 on Tuesday, July 30th. Anything that you contemporaneously email a copy of it to Ms. Rosser, because the court and chambers do not automatically get what y'all file. I have no idea what you filed unless you actually let us know. So make sure that when you file it, you send a copy to Ms. Rosser so that we know about it. Okay. All right, so I'll plan to see everybody bright and early at 8:45 on Tuesday, July 30th.
Oh, we're good. We're done. Thanks.
All right. Don't leave until you make sure Ms. Rosser has your cell information.
Can
All
I
right.
ask a question?
Yes.
Judge Glanville had, for both sides, 2 Fridays before that tell the other side what witnesses and what exhibits are going to be in play. I would hope that continues. That was very helpful.
That sounds like a good idea. So sure, we can leave that as sort of a standing rule. And I suspect that this is true as well, but let me go ahead and say that as we're going through trial, I expect you to have your next witness ready to go. I don't want there to be a 5-minute pause between one witness getting off the stand and the next witness getting on the stand. And the state knows, we're in the state's case right now, the state knows what it's doing, the state has investigative help. Make sure you have enough witnesses to carry us through each day and then they're ready to go. Again, that all just kind of falls under the auspices of let's be respectful of the jury's time. Mr. Harvey?
Can I assume, Judge, that we are going to continue with the opt-out rule so that you're not going to get all 8 of us standing up going, I'm in too?
Yes, no, that's a great idea. Let's continue with that rule as well.
Thank you.
I mean, I plan to basically continue with the rules already in effect unless there's some reason to change them. So I hope if there is something, y'all can bring it to my attention. Otherwise, we'll just keep rocking as before. All right, thanks everybody.
So, remember the press, there was a rule in place for the members of the press to keep the witnesses on Fridays, or someone would be excluded to be shown on camera. I want to make sure that's still in place.
Okay, so I guess y'all would have agreed beforehand that a particular witness shouldn't be shown on camera, and then who gave the list?
The state has been providing to members of the press the list of those persons, and the judge has made rulings regarding those.
So I saw a ruling that said if there's somebody who, for whatever reason, shouldn't be shown, whatever kind of concerns, then they won't be shown. But
it wasn't exhaustive.
It seemed that was kind of a witness by witness thing, and that there was an opportunity for input.
Yeah, there's an order that the judge entered, and there were certain reasons that the state could request that witnesses not be televised. I believe that was to be provided to us the Friday before, and then we would have the opportunity.
I like that. Judge, I like that ADA Love goes to the podium to address the court to be formal. But it's just funny that Weinstein never goes and he's just talking and talking and talking.
Opportunity to get to that by Monday,
right? And
then the judge would make a decision based on his criteria whether that witness should be shown on television or not.
Right.
And I believe that Mr. Harvey has a standing objection to all witnesses at this point.
Okay, wait, to all witnesses being shown or being excluded? Okay, well,
No witnesses excluded. I don't speak for Mr. Harvey.
All right.
And I'm incorrect.
okay, well, that's why I guess it's being taken up on a case, witness by witness basis. So, Ms. Love, then you're providing that to the court and opposing counsel. If there's objection, we're litigating it. And then are we saying it's like the next Friday that we then tell the press, or help me out on that?
Ms. Hilton said she has been providing that list. I will let her explain to the court.
Okay, because I guess I'm wondering, how is there a list if there hasn't been either agreement or a decision on it?
I believe, I'll let Ms. Hilton start, because she's the one that initially
Okay.
prepares the list.
All right.
Good morning, Your Honor.
Good afternoon,
Your Honor.
Honor.
What has happened is the week before, certain witnesses were going to come up the following week.
Okay.
We would identify any of those witnesses that we are asking not to be shown. We would forward that to the media as well as opposing counsel. They would then decide, object, and we would hear on Monday the ruling from the court.
Okay, well, so then with regard to the media's inquiry, it sounds like what y'all have been getting as a list from the state is kind of the preliminary. We think this might be the case list, but Ms. Hilton, do you then give them and here's what our determination was list, or?
So normally the court has put on the record that Monday, whether or not that witness should not be shown.
Okay, so y'all you've got your list and you either strike that person off because I said they can be seen, or you just go with what's on there. Okay, that makes sense. So yes, we'll continue with that as well. All right, we are in recess.
All right. The state of Georgia seal, 1776. Very good. Thank you. Thank you, Georgia. Thank you, Fullerton County. Thank you, Judge Whitaker. ADA Love and ADA Hilton and team is still in place, so there was no recusal to them. Today was administrative in nature, but this is how you kind of fulfill the right to a speedy trial, is to have status conferences, scheduling conferences, and so forth. So this is what the preliminary things look like in the first place. So if you didn't see it in the beginning with Judge Glanville, because we weren't around, like, honestly, or maybe it wasn't televised, not to say he didn't do it, but this is what it looks like. No biggies here. Interesting, maybe boring, maybe, but I think some digs were had. But so far, nice even kill. ADA Love is trying to build her rapport with the judge. The defendants attorneys feel like they can finally be heard. There's that impression so far. And it sounds like the judge is looking forward to being consistent and structured. Those are her themes. And so we're very happy for consistency and structure. And hopefully all parties will abide by that and help this case come to a conclusion. Brian Steele was very quiet. But I didn't want him to be so quiet. I don't know him at all, but I didn't know he was quiet. So this is good. This is good. He's happy. This is my opinion. This is my interpretation. Totally speculation. Like, what do I know? I don't know these people, and they don't know me. I'm making it up. But this is my impression based upon the body language and the encounter. So in the comment section, tell me, what is your impression? How do you feel? Do you think we might figure this out before, I don't know, our next life? You know, everyone's trying to be a butterfly. Can we at least solve this before we all become butterflies? I don't know. I don't think we will be, but you know, all good things must end. They must come to an end at some point. So this is the end of the stream. I hope you have enjoyed yourself. So sorry for all those commercials, but you know what? Like, share, and subscribe. And I appreciate you, Lyric Armstrong, real estate agent and advocate and paralegal commentator.